Okay, Ms. Rodriguez, can you hear us?
Yes, I can hear you now. Thank you.
Okay, very good. Okay, on the record, in the matters of the people of the state of Michigan versus William Schultz, Clifford Frost, Myra Rodriguez, Rose Rook, Marion Sheridan, and Kenneth Thompson, council appearances.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Kayla Crino, appearing on behalf of the people.
Morning, Your Honor, Dave Coleman on behalf of Mr. Choate. He is here seated right in front.
I don't know if I'm doing this in the right order, but Michael Volata, good morning, Your Honor, on behalf of Ms. Roosevelt. President Court.
Morning, Your Honor. Right Blake appearing on behalf of Myra Rodriguez, is present via Zoom.
Good morning, Your Honor. May it please support Attorney David Gilbert appearing on behalf of Mr. Ken Thompson. Mr. Thompson is in the courtroom standing to my immediate right. You identify yourself in the court, please.
Morning, Your Honor. Ken Thompson.
All right.
Kevin Kiefsky on behalf of Mr. Clifford Frost, who's immediately behind you.
Morning, Your Honor. Attorney John Freeman on behalf of Marion Sheridan, who is seated behind me.
Okay, today is day 2 of this examination, and we left off with your witness. I think you were about to admit another exhibit with Special Agent Shock.
Yes.
Okay. Any matters we need to address before we continue with testimony? Okay. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
You have a seat.
Permission to approach, Your Honor.
Yes.
So I'm going to hand you what has been marked as People's Proposed Exhibit 23. Could you briefly look through that document? Do you recognize that?
I do.
And what is that?
The first page is the certificate of authenticity of records. This is for the meta records for the account of Clifford Frost.
And you're reading that information from the second page of that document, is that correct?
Yes.
And after the second page, how many additional pages are contained in People's Proposed Exhibit 23?
2 more.
Okay, and do you recognize those 2 pages as coming from the meta return for Clifford Frost's Facebook page?
Yes.
People would move to admit Proposed Exhibit 23.
No objection.
I don't know if I have to make this objection, Your Honor, but I would ask that it not be used in my plight. Their statements made by other defendants.
But it will not, I think she prefaced that in the beginning, so the,
But I just want to,
okay, no problem. Okay, People's Exhibit 23 is admitted.
I'm cited, Judge. Now, referring to the 3rd and 4th pages, could you tell us what kind of content are on those pages?
There is time, type indicates comments, summary, the comments, an object ID number.
So are those posts that are that were found within the return for Clifford Frost?
Yes.
Now, on page 3, is there a highlighted section?
Yes.
Okay, could you tell us the date and time for that?
2020, December 14th. Time would be 20, this is military time, 22:11 hours and 5 seconds UTC time.
And who is the author of that post?
Clifford Frost.
Could you read the post, please?
Highlighted or the whole post?
Whole post.
The whole post, okay. Summary, Clifford Frost commented on a post from December 14th, 2020. You are right, comma, Tanya, exclamation point. I am an elector and refuse us entry to the Capitol, ... More to come, comma, later.
So in that post, did that contain any contingent language, like I may be an elector? It just said I'm an elector?
No.
Looking at page 4. Is there a highlighted post on page 4?
Yes,
Could you read the date and timestamp for that post?
2021, January 7th. Time would be, again, in military time, 13:50 hours, 59 seconds UTC.
And who is the author of the post?
The Clifford Frost,
And could you read the post, please?
just the highlighted or the whole post?
Whole post.
The failures of our own GOP party are disgusting, period. I am an elector and they failed us in Lansing, comma, repeatedly, period. ETW, comma, Sharon is a precinct delegate and state GOP committee member, period. She is very disappointed, comma, too, period.
Thank you. Permission to publish to the court?
Yes.
Take that and switch out. Sarah, handed you what has been marked as People's Proposed Exhibit 24. How many pages are contained in that document, sir?
2 pages.
And do you recognize that document?
Yes.
Could you tell us what that is?
Certificate of authenticity of records from Meta. And then the account records from Meta platforms for Mrs. Marianne Sheridan.
And you said there was a, there, do you recognize those as Meta records that you requested and received for Ms. Marianne Sheridan's Facebook?
Yes.
She's what moved to admit People's Proposed Exhibit 25. I mean, excuse me, 24. Any objection?
What, Your Honor?
Yes.
How did you come to possess the document that you're holding now, when you first got it?
Through a search warrant?
So you issued a search warrant to Meta, and this is the response that they gave you?
I submitted one, yes, and this is the response.
And they gave you 2 pages in response.
No, sir.
What did they give you in response?
They gave us the account records for the account name subscriber for Marian.Sheridan.5.
And how much material did you receive?
I don't recall.
Approximately.
I'll say there was a lot of pages, more than 100,000.
Thousands of pages. weren't
Yeah, there was a lot.
there? Several thousands.
It could have been. I mean, there was many accounts that had several thousands of pages. I don't recall specifically how many pages this one.
Was there anything that would refresh your recollection?
Yes,
What?
the entire return.
Do you have that?
In front of me? No, sir.
Where is it?
So it would be stored in our records management system.
So as you sit here today, you can't tell us how many thousands of pages you received as a result of the search warrant that you are now proposing to introduce 2 pages. Is that fair to say?
I'm not proposing to introduce anything. I'm saying that I don't know how many pages were on this particular return.
Can you give us, but you can't even approximate how many thousands there were?
There's other than thousands.
No objection.
People's 24 is admitted.
Thank you. And of the thousands of pages that came from the Marianne Sheridan return, those 2 pages were part of that return, is that correct?
Yes.
Now, on the second page of Exhibit 25, does it provide an email associated with that Facebook page?
25 or 20?
24, I'm sorry, excuse me, 24.
Yes.
And what is that email address, please?
It's registered emails Marian@Sheridan-net.us.
Thank you. Now, I'm gonna ask you to look at people's proposed exhibit 25. Permission to publish 24, Your Honor?
Yes.
Have you had an opportunity to look through those documents?
One moment.
Mhm.
I'm still looking.
And do you recognize those documents?
Yes.
What are those documents, sir?
There are emails between,
Objection, Your Honor, is to the foundation.
The foundation is doing respond.
Well, the witness has to describe what the documents are before I can lay a foundation.
The foundation first.
Yes, I identify the object.
Identifying what the document is first, correct?
Yes.
Well, he's representing that there are certain emails.
He said he's representing that there's certain emails.
Yes.
I don't know what's on the document. I'm assuming you do. You know what's on the document?
I assume it's the exhibit that I was provided about 20 minutes ago.
Objections overruled. Thank you. Continue.
Please describe the documents, sir.
yes, there, an email exchange between, the email address is, Ken Chesbro at msn.com to, Marion Sheridan, marion@sheridan.net.us. And then there's, some attachments or additional documents that are in here as well, the certificate of votes with
Well,
the,
you're getting ahead of me.
okay.
Okay. Now, the document proposed 25, how many emails does it contain? They should be lettered up in the upper right.
Oh, I see. Great.
Your Honor, I'm going to object. It sounds to me like the exhibit that the witness has is not the same exhibit that I was provided. The one that I was provided does not have lettering. Your Honor, I'd like a copy of what it is the witness is going to be referring to, because this is not the same as what I did.
It's the same exhibit, you just don't have the letters. You have the exact same document.
I'm sorry, what are the letters?
A, B, and C, which were handwritten by me.
Oh,
Your Honor, I'd ask that I have a copy of the exhibit that the witness is using. I don't have that.
it's the same exhibit and she hand wrote A, B, C, and D on them?
Just A, B, and C.
I'd ask for a
I'm
copy.
asking you a question. I don't know what you have. Is it the same exhibit, but she hand wrote A, B, C, and D on them?
So this morning I was provided 13 pages that I was told was proposed exhibit number 25.
Is that 13 pages?
Yes.
I'm gonna let him.
Yes, it's 13.
Okay, and does it appear to be the same? What's the difference other than the fact that she wrote A, B, C, and D on them?
My point is, Your Honor, is.
But no, that's not an actual point.
I'm sorry,
Actually,
what
my
was the court's
question.
question?
What is the difference other than she wrote A, B, C, and D?
Based on my cursory review right now, it does not appear that there is.
Okay, your objection's overruled. We can continue.
For clarification, I'd ask if it could be explained to me of the 13 pages, which pages are designated A, which pages are designated B.
Well, you have it there.
Well,
And I'm also-
apparently
I don't
I'm not
know.
going to be able to keep this.
I'm gonna do it with the witness.
Okay. It's not in order?
They are in order.
Okay. And it's in the same order, that document's in the same order as the document you provided him?
Yes.
Okay, thank you. Give her the document.
Now, specifically referring to the email that is labeled A. Can you identify how many pages are contained in that email? Or remove the paper, it's stapled together.
I got you. Six.
And the participants in that email were who again?
Mrs. Marianne Sheridan and Mr. Kenneth Chesbro.
And is there a date at the top of the first page, a date and a time of that email?
Yes,
What is that date and time?
December 10th, 2020, 8:51 p.m.
And moving forward to the email that is labeled B, could you tell us how many pages are contained in that email?
In what letter?
B.
B.
And who are the participants in that email conversation?
Mr. Kenneth Chesbro and Mrs. Marianne Sheridan.
And is there a date and time at the top of the first page?
Yes,
What is the date and time of that page?
December 10th, 2020, 10:26 p.m.
And the email conversation labeled C, how many pages are contained there?
1.
And who are the participants in that email conversation?
Marianne Sheridan and Kenneth Chesbro.
And is there a date and time on that email?
Yes,
And what is the date and time on that email?
December 14th, 2020, 6:21 p.m.
And have you reviewed the email conversations that are labeled as A, B, and C in people's proposed 25?
Yes,
And does that conversation pertain to the gathering of the Republican elector nominees and the possibility of the Republican elector nominees voting in the
yes,
state of Michigan, excuse me? People would move to admit people's proposed exhibit 25, Your Honor.
Any objections to 25?
My dear,
Yes.
these emails, were they part of the receipt that you received for the subpoena, I'm sorry, for the search warrant for the Meta company?
the ones that I just read, no.
Where did these come from?
Mr. Kenneth Chesbro
So these were given to you by Chesbro himself.
and his attorneys, yes.
When did that occur?
December 6th, 2023.
Your understanding that these emails were between Chesbro and someone named Marianne Sheridan comes from your listening to a conversation and in fact conducting a 4-hour interview with Chesbro in December 2023, correct?
December 20,
in December of twenty
Oh,
twenty-three.
oh, yes,
That's how you can reach the conclusion that these emails in fact involve Chesborough and Marion Sheridan,
yes,
correct?
yes, sir.
This is not something that comes to you through the search warrant, for example,
The search warrant for Meta?
correct?
Yes, sir.
And no other search warrant, correct?
No, sir. Correct.
Chesborough, is your understanding that he's going to testify at this preliminary exam?
I don't know that, sir.
Have there been any discussions about that?
If there has been, yes, there has been.
You're the lead investigator in this case, correct?
Yes,
You're aware of the strategy of the case, correct?
yes.
Is it your understanding that Chesborough is going to be called to testify at this exam?
This particular exam, I'm not aware of that, sir. At the previous exam.
I'm not asking about the previous. exam.
Okay,
At this exam, is it your understanding that Chesborough is going to be called as a witness?
no, sir.
Your Honor, I object because the basis for all of this is hearsay.
Well, statements by party opponents are not hearsay pursuant to Michigan Rule of Evidence 801(b)(2)(b). And also if the court will remember, I elicited the date and times of the emails for a reason, to show that these are also statements in furtherance of the conspiracy. The content will further explain how these statements correlate to the conspiracy which the defendant is charged with. The defendant is charged with conspiracy to commit election fraud and election forgery. And these statements, not only the date and time and the content, that these were statements in furtherance of that conspiracy. But again, the statements of Marion Sheridan are not hearsay, and the statements of Kenneth Chesborough are not hearsay because, one, they give context to Marion Sheridan's statements and their statements of a co-conspirator. Unindicted as he is, they are in furtherance of the conspiracy, and therefore they are categorically not hearsay.
Objection is overruled. People's 25 is a minute.
Sorry, Your Honor. I just want to say for the record that I object to anything being used with the co-conspiracy over the co-conspirator statement exception against my client. I don't
This
think there's-
particular exhibit, you say you're objecting to.
No,
being
no, I'm
used-
just saying in general, the statements been made, the representations been made by Ms. Logan, that these statements between electors and other people could be co-conspirator statements. And my objection is going to be, that is, she intends to use other statements as co-conspirator statements.
Okay, I can't address that until it happens. If it happens, you'll need to make an objection.
I just object to her categorizing that as a co-conspirator statement, because she would have to first prove the existence of the conspiracy, in which she can't use the statements themselves in the Michigan law. So just objecting to that concept.
Okay,
Thank you.
I joined it. Gilbert Thompson, I would join that also. I'm sorry, did you hear me?
I could hear you.
All right, thank you.
It's more, she needs to hear you too, though. And you're right in front of the mic, so you're probably good. Did you want to respond to their objection?
Well, I will respond to that. I think, Your Honor, that there's more than enough evidence on this record that a conspiracy exists. Evidence of a conspiracy can be established either by explicit statements or the conduct of the defendants. And in this case, we have at least 16 people coming together to sign what the people allege is a forged fraudulent document, and then publishing that document. By 16 people coming together and signing that document, we can definitely infer that they are acting in concert. I think we also have statements that are on the record, but as I said yesterday, for the purposes of the exam, I'm only intending to use statements of the defendants against the declarants only. So as for right now, these statements are only being used against Ms. Sheridan.
Correct, and that's the purpose for which they were admitted. And I've already indicated, should this further present an issue for your objections, then you'll note it at that time, okay? Thank you.
Special Agent Shock, I'm going to draw your attention back to the email labeled as A, which is the first email. Now, on the bottom of the first page, do you see that there's an email conversation there, correct?
Yes,
Well, an email, correct?
yes,
Who is the sender of that email?
Mary Ann Sheridan.
Objection, Your Honor, that assumes facts that are not in evidence. It certainly appears that it comes from an account that is associated with Mary Ann Sheridan, but there's been absolutely no foundation established who actually wrote the email.
Well, that goes towards weight, not admissibility. As it relates to the proofs, it has been established that that is an account that is associated with Mary Ann Sheridan. As for her Facebook page, she uses that exact same email address. And whether the court can make the determination whether or not you believe that the speaker is a defendant or someone else, that's a question of fact.
It's definitely a question of fact for a jury.
Well, I think that the appropriate answer is that it's an email that came from that particular address. But
You can't tell,
to
you
reference-
can't tell the witness how to answer the question.
Well, I think it's,
I recognize that that would have been a nice way to answer it, but that's not how he answered it.
well, that's my objection. It's-
Okay.
It's not factually.
Your objection is noted. It's over with.
Looking at email A from Exhibit 25. The email at the bottom of the first page, who is the sender?
Mary Ann Sheridan.
And what's the email address associated with Mary Ann Sheridan?
Mary Ann at Sheridan-net.us.
And who is the recipient of that email?
Kenneth Chesbro.
Is there a subject line?
Yes,
What's the subject line?
would you like me to read it?
Yes, please.
Reference or RE semicolon urgent dash Trump Pence campaign asked me to contact you to coordinate December 14th voting by Michigan electors.
And could you read the body of that email?
Hi Kenneth, comma, while Kathy Benton is an elector, comma, so am I. And I believe your email was intended for her, comma. Nonetheless, I believe I can be more effective in getting the other 15 electors involved in this effort for December 14th.
I'm sorry, are we reading? I'm asking for clarification. Are we reading the first email that appears
We're on
on
group,
page 1?
we're on email A, which is the first page, but the email at the bottom.
First email is from Kenneth Chesbro to Mary Ann Sheridan.
The
Is
email
that
at
the
the
one that
top,
we're reading?
the email at the top is from Kenneth Chesbro. The email at the bottom of the same page is from Ms. Sheridan.
Well, Your Honor, I think the rule of completeness requires that it all be read into the record.
Well, it's all been admitted and I'm allowed to introduce my proofs in whatever order I choose.
The entire email chain has been admitted, so I don't think she needs to read it or have her witness read the whole thing on the record. The court can read that.
Actually, I intend to introduce it, but I'm trying to go in chronological order.
Okay, so the email he's talking about is not before, or I'm not following.
The email response from Kenneth Chesbro is at the top of the page, but it is sent in
In
response
response
to
to the one
email
you
at the
mean,
bottom.
got it. Okay,
And Your Honor, also I have a concern that my client's email is now part of this record that's been live streamed. I think that the actual use of the email address needs to no longer be done. It shouldn't be used anymore. Right.
the actual use of the email address,
Should not be referenced on the record any further.
I'm gonna get a
It's
foundation
personally
objection.
identifiable information.
okay. You said you want to do what?
I said, then I'll get a foundation objection. But I will stop using the email and I will just ask the witness to identify just the sender and not the email address. Could you please complete the email?
Let me contact the other electors if you haven't and work on this plan, comma, sincerely, comma, Mary Ann Sheridan.
And what's the date and time on that email?
December 10th, 2020, 8:44 p.m.
Now going to the top email on A. Who is the sender of that email?
Kenneth Chesbro,
And who is the recipient?
Mary Ann Sheridan,
And what is the date and time on that email?
December 10th, 2020, 8:51 PM.
And does Chesbro respond to Ms. Sheridan's email?
Yes,
And as part of that response, does he attach documents?
yes,
And in group A, do you have a copy of one of the documents that Mr. Chesbro attached?
yes.
Can you tell us what that document is?
Is the certificate of the votes of the 2020 electors from Michigan for President Trump and Pence, along with signature page, and then a certificate of filling vacancy of the 2020 electors from Michigan.
Permission to approach, Your Honor?
Yes.
I'm gonna hand you what has been admitted as People's Exhibit 11, and I'm turning your attention to the second and third pages. Now, the document that's attached to the email sent to Ms. Sheridan, are those the same documents?
Yes,
Now, are there differences between the document in Exhibit 11 and Exhibit 25? The
yes.
attachment. What are the differences?
The one that exhibit number 25 says that we convene and organize at the state capitol in the Senate chamber. In exhibit 11, that is left out there. Here's the difference.
And looking at that first page of the document that was emailed to Ms. Sheridan, are the number of votes already on there?
Yes,
And how many?
16.
This is on December 10th, 2020, is that correct?
Yes,
Looking at the, I guess, signature page that was attached to the email. Does it have signatures?
no, it does not.
Whose names are on the document that was emailed to Ms. Sheridan?
Would you like me to read them all?
Well, if you can identify them in a collective way, that's fine, but if you want to read them all, that's fine too.
I'll read them all. Kathy Burden, Marion Sheridan, Michonne Maddock, John Haggard, Kent Vanderwood, Terry Lynn Land, Gerald Wall, Amy Facinello, Rose Rook, Hank Choate, Marianne Henry, Clifford Frost, Stanley Grote, Timothy King, Michelle Lundgren, and Myra Rodriguez.
And what is the significance of those 16 names on that document?
It would be the same individuals who were nominated at the state party convention back in August of 2020.
And on the document that's emailed to Ms. Sheridan has a title on that document, doesn't she?
Yes,
And what's that title?
secretary.
Now, looking at the similar page, I believe it's the third page of Exhibit 11. Is Ms. Sheridan still identified as the secretary on that document?
No,
Is there a secretary identified on that document?
yes,
And who is that?
Myra Rodriguez.
And are there any names that are different on Exhibit 11, page 3?
Yes,
Which names?
James Renner, Kenneth Thompson,
And they replace, who are they replacing?
Terry Lynn Land, and Gerald Wall.
I ask you to move forward to the email identified as B. Who's the sender of that email?
Kenneth Chesbro,
And who is the recipient of that email?
Marianne Sheridan,
And what is the date and time stamp on that email?
December 10th, 2020, 10:26 p.m.
And is there another attachment to that email?
Yes,
And can you tell us what that attachment is, sir?
it's the memorandum, which has two President of Senate, Archivist of the United States, Secretary of State, Chief Judge, U.S. District Court from Kathy Burden, dated December 14th, 2020, reference Michigan's electoral votes for president and vice president.
Looking at Exhibit 11, is that the same cover page that is on that document?
Yes.
And moving forward to the email labeled C. Who is the sender of that email?
Marianne Sheridan,
And who is the recipient of that email?
Kenneth Thompson, Kenneth Chesbro,
And what is the date and time on that email?
December 14th, 2020, 6:21 p.m.
And what is the text in the body of that email?
We did it, exclamation point.
Mary. Permission to publish, Your Honor? Sir, I'm going to hand you what have been marked as People's Proposed Exhibit 26. You recognize that document, sir?
Yes.
And what is that document?
So first page is a certificate of authenticity for Meta. The following pages would be the business records for Meta platforms for the account. A ration.
And is that a Facebook return that you requested?
Yes,
And whose Facebook return is Kenneth Ration associated with?
Kenneth Thompson.
And how are you able to connect Kenneth Thompson to a Facebook profile of Kenneth Ration?
Just through subscriber information, whether that's emails or photos and things like that.
And you said that that was a return that was sent from Meta along with the certificate of authenticity.
Yes,
And the following pages are portions, but not the complete return for Kenneth Ration. Is that correct?
yes,
And the portions that of the return that are included within Exhibit 26, are you able to tell us whether or not those pages pertain to December 14th, 2020, and the Republican nominees at the, I guess, at the Capitol?
yes.
People would move to admit People's Proposed Exhibit 26.
What here?
Yes.
You said you were able to associate that account with Mr. Thompson, is that correct?
Yes,
What was the link that you established?
not, I don't
How did you
understand.
associate it? What information did you use to make that association?
I don't recall, but typically it's through emails,
I
phone numbers, and
Don't
stuff
want
like that. So
Can you let him respond, please?
I said I don't recall. So
So you don't know how you link that to Mr. Thompson?
I said I don't recall how.
Something that you can use to tell us, because that seems to be pretty important information. You're coming in here alleging that that is linked to Mr. Thompson, but yet you cannot tell us how it is.
Probably,
linked.
probably through the reports.
I don't want speculation. I want the fact of how did you link that to Mr. Thompson?
I don't recall.
So as we sit here, you cannot link that to Mr. Thompson.
I don't recall.
I'm gonna object. This is no relevance to this. He can't link it. He's just assuming that it's linked. He can't tell us how it was linked. So that would be the same as me coming in and saying, I got this Facebook account and I'm linking it to George Jones. And I don't remember, or I can't recall how I did it. So it's
Do you want to respond?
I think I would like to ask for a brief recess, so Mr. Agent Shock can look through his digital notes, so he can testify better as to how he linked this, this Facebook return to Mr. Thompson.
He was asked if there was anything that can help him refresh his recollection. I don't recall him saying that his note's good. Agent Shock, is there something that you have access to that can refresh your recollection as to how you linked this account to Mr. Thompson?
It would probably be in my notes, ma'am, through reports or material in the case file.
Okay, and where is your case file?
Be on my computer.
We can have, how long is it gonna take you to refresh your recollection on that?
And
10 minutes?
And just as a suggestion, the search warrant that you sent to Meta, would that include information, how you established a link between Mr. Thompson and the El Russian Facebook profile?
it should.
And would you
I'm
have a
gonna
copy?
object to the question. That's leading. He was asked a specific question. He doesn't know how. If they want to discuss it after or off the record, that's fine. That's a leading question.
Well, it's just a
Okay.
question as to what would refresh his memory. That's it.
I can understand, I'm trying to identify specifically, so he's not rummaging through thousands and thousands of pages in the 10 minutes he's about to get to do that. So we'll recess for 10 minutes to allow him to refresh his recollection. Off the record.
Thank you.
Back on the record. If Agent Sharp, you were given an opportunity to refresh your recollection as to council's question, you can respond.
So I used a database to research Mr. Thompson, which would give me like phone numbers, addresses in the past, email addresses and things like that. The phone number that shows up on this report also matches the phone number that's on the subscriber information for the account.
Specifically, what database did you use?
So we use a few of them, Clear, Accurate, and then there's also the state police provides a report as well. I'm not familiar with what database.
So you use 3 different sources to tie that account to Mr. Thompson personally, is that correct?
Yes,
Do you still have that information that was used to bring this all together?
Yeah.
Yeah. You provided that to the prosecuting attorney yet?
yes, everything should be in the file.
I would ask if that hasn't been turned over, that would be turned over in the course of discovery, so I can make the same connection. Thank you.
Everything's been turned over that I have, so it unfortunately is thousands of pages of documents, but anything I have.
Okay, people's 26 minutes.
Thank you. Now, I would like to turn your attention to the 3rd page of Exhibit 26. Do you see on that page, probably somewhere in the middle where it says thread?
Yes,
Does it identify the participants of that thread?
yes.
And who are the participants of that thread?
Darlene Thompson, Kenneth A. Ration, Matt Maddock, and Sean Maddock.
Now, when you reviewed social media return in its entirety, did you find information that related back to the Republican nominees for elector being in the Capitol on December 14th, 2020?
Yes,
And are those, specifically, did you find photos within this return?
yes,
And are those photos contained in Exhibit 26?
yes.
And how many photos did you find that related to the Republican nominees for elector being in the Capitol on December 14th, 2020? And I guess specifically, I'll turn your attention to page 10 of that document.
There's 12 photos here.
Are they duplicates?
Some of them, yes.
Okay. Now, are you still on page 10 of the document?
So. And where if the pages are actually numbered?
The 10th page, because there's another number at the top, which I'm gonna have the witness identify.
So they're not actually numbered. At least not what she's referring to the 10th page, not page number 10.
Yes.
What is the number at the page number at the top of that page?
6,540.
Is there a photo on that page?
Yes,
What's the photo?
it's a photo of all of the Republican electors.
I'm gonna ask you to go to the ninth page, which is one page forward. And what's the page number at the top of that page?
6,539.
And at the bottom, does it identify who sent that photo?
Yes,
Who sent that photo?
Kenneth A. Ration.
And is that part of the thread that contains Darlene Thompson, Kenneth Ration, Matt Maddock, and Sean Maddock?
Yes,
And that information that's found on the third page of Exhibit 26.
yes,
What is the meta page number for that third page?
6,533.
And just for clarification, starting with that third page through the end of the meta documentation that is part of 26, are those in sequential order?
Yes,
Now, the photos that are sent within that thread, do they all have the same sender or different senders?
they all have the same sender.
And the last 6 pages of Exhibit 26, do you recognize those photos?
Yes,
Are those the same photos from the actual return?
yes,
They're just larger?
yes,
So is it fair to say that there are actually 6 photos that are sent within that thread?
yes,
Now, looking at the larger photos of the photos that were actually taken from the thread, are you able to identify any of the defendants, whether they're present for this exam or they were part of the first group of defendants?
yes,
And starting with the first page, can you just identify and then display the photo of which defendants are in the photo?
yes. Sean Maddock and Clifford Frost. Go through them all.
Yes.
Okay. And then the second photo. Third photo would be Michonne Maddock, Marion Sheridan, bless you. Clifford Frost. Fourth photo would be all the Republican electors that signed the certificate of votes. And I can list those: Kent Vanderwood, Myra Rodriguez, Stanley Grote, John Haggard, Marianne Henry, Sheridan, Timothy King, Clifford Frost, Hank Choate, Kathy Burden, Kenneth Thompson, Rose Brook, Michelle Lundgren, Michelle Maddock, Amy Fechinello, and James Brown. This is a duplicate photo, again, of all the same individuals. This is page number 5. And page number 6, there's Amy Fechinello, Marianne Henry, Timothy King.
Special Agent Schott, as part of your investigation, did you have to look back at the state of any election controversies that occurred during the elections, the 2020 presidential election season?
Yes.
Okay, and before electoral college vote that occurred on December 14th, 2020, were you able to determine if a recount had been requested?
Yeah.
Was a recount requested?
No.
Before December 14th, 2020, were you able to determine if there had been any successful legal challenges to the Michigan presidential results?
We're not finding successful.
Before December 14th, 2020, had there been any state legislative action with regards to either the Michigan presidential election results or pausing the electoral vote?
Yeah.
There had been?
You're talking about a legislative action,
Yes.
not to pause the vote, no. But there was the McBroom report, there was a special committee that was that had convened shortly after the election to investigate fraud or irregularities.
And did that investigation result in a change in the Michigan presidential results?
No,
Did it result in a pause or a delay in the electoral vote?
Well, Your Honor, I'm going to object to this. The McBroom committee and all that was after December 14th, so I don't see the relevance of anything that happened that the Senate did a year or two later would have had any impact on my client or any of the other Republican electors. So I object.
I would also join that objection, Your Honor. And furthermore, I believe these are asked and answered from yesterday. There's several questions, almost exactly identical, I believe, as it relates to state legislative action, talking about recounts, all of these things. So I believe that was all covered previously.
I'll move on.
Oh, I just want to put one objection on the record. I object
Go ahead.
also. Oh, I'm sorry.
No, you
I
go.
didn't see you were standing there.
It's okay.
Especially.
How can you miss me?
Okay, you can proceed with your objection.
Yeah, so the objection is, it's just that it's irrelevant, because my understanding is this report, it was the Senate Oversight Committee, State Senate Oversight Committee, the report came in, I'm told in June of 2020, 2021. So it would be irrelevant to their mindset at the time they signed it. So irrelevant, that's my objection.
I'm gonna take the whole basket of objections on. behalf
Join
of
the
the chair.
objections, all the objections.
Your Honor, so is that stricken then? Is our
She said
objection-
she was gonna move on. I was gonna,
Well, moving on.
yeah, are you making an objection or joining the objections?
Joining Gilbert for Thompson.
Thank you.
Well, just as a response, I know the final report was after, but I believe the investigation convened before December 14th. And I'm just asking if the inception of that investigation affected December 14th. That's it. So I think that's still relevant.
Well, again, Your Honor, I'm not aware, unless there's proof of that. My understanding was the Groom's committee and everything was done after that.
I don't
And
think he
again,
needs
I
to
just want
provide
the
any
record
proof.
to
I
be
think
correct.
the question was he aware of any? He's
But
not.
again, if it's after December 14th, it's irrelevant. And I asked that the response to that be stricken for the record. And moving on leaves it in the record.
I
So
think we all
asked-
have a different understanding as to whether or not it had been initiated or not, and we don't have that information before us. But I think she agreed to move on. Is that?
Yes.
So
Well, is it
It's
gonna be
stricken.
considered by the court? Then the answer or not?
it's not.
Okay, thank you. That's all. Thanks, Jeff.
Part of your investigation, did you look at anything that may have occurred after December 14th, 2020, to see if that would have affected who was appointed as electors for the state of Michigan?
Yeah.
And after December 14th, 2020, did you find any evidence that a recount had been requested?
No,
Did you find any evidence that after December 14th, 2020, a recount had been ordered?
No,
Did you find any evidence after December 14th, 2020, that there have been any successful legal challenges?
Again,
to-
Your Honor, I'm gonna object to this because it's after December 14th and it's irrelevant. It would have no impact on my client's state of mind on that date contract. So it's fine. The question, anything that happened after the 14th.
Join.
Join.
Your Honor, as an offer of proof, there will be a subsequent witness that was provided information that what they were doing on December 14th, 2020 was contingent on what they expected to be legislative or state action that would render their actions legally valid.
In Your Honor, I don't see how that changes the objection. I mean, something they found out subsequent. The issue here is my client's state of mind. What was his intent on December 14th? Anything he found out later, all of it, it doesn't matter. It's irrelevant.
I would accept her offer of proof and ask for dismissal. She just admitted that they didn't know that their actions were based on contingency of upcoming or pending litigation. So based on her offer of proof, I accept it and move for dismissal against my client.
I did not admit that. I said there was a witness that was.
I
told
have a
that.
motion. before-
There's been no witness presented, and she says there's going to be a witness that's gonna testify as to what
What he was told.
he was told as to what.
An offer of proof is an officer of the court coming before the court saying these are the facts as I know them and I can prove them. Doesn't-
Her offer of proof was that there will be some testimony, though.
Her offer of proof. Exactly what she said, the entire comment. Offer of court wishes to take it, I'm not gonna argue.
Her offer of proof was not that this is what happened, but her offer of proof was that there will be testimony to that effect. And so I wouldn't first need to see the testimony that she's offering.
That's fine, I just made my motion.
Thank you. And that motion will go in your final argument. Thank you.
Can I proceed?
You may proceed.
Okay, thank you. After the vote on December 14th, 2020, did you find any evidence of any state legislative action that either resulted in a change in the Michigan presidential results outcome or anything?
Objection, Your Honor. I believe it was asked and answered.
Well, again, I object. It's irrelevant. It's after the fact.
Yeah, I'm overruling that objection because I think it is relevant as to what happened after the fact. If the theory, as I understand it, is that this action was taken thinking that it would affect something in the future. So the objection is overruled.
Thank you, Your Honor.
no.
Ask the witness, Your Honor.
Cross-examine.
Do you have any other exhibits? Motion to publish to the court exhibit 26. Oh, I've got one. Well, I don't.
We can proceed.
Thank you and good morning. What's your title? Investigator Shaw? How should I address you?
Howard, just address me as Howard Shaw,
I'll just call you Investigator Shaw because first name.
whatever you feel more comfortable with.
Appreciate it. Investigator Shaw. What year did you graduate college?
97. It's been a while, sorry.
And where did you go to school?
College?
Yeah.
I graduated from Michigan State.
And then what were your jobs? When did you get into law enforcement?
Following graduation.
What did you do?
I was a police officer,
Where?
Meridian Township.
Where is that?
It's right around here. It's Okemos and Hazlet area.
Small town?
30, I think the Charter Township, 36 square miles. So
Small population.
I don't recall what the population was at the
What
time.
kinds of cases did you were you involved in prosecuting cases, investigating them?
I was involved in taking complaints, and any complaint that you received, it involved some level of investigation.
They mostly misdemeanor investigation.
I don't recall.
How many years did you work as a police officer for Meridian Township?
Here
Where'd you go?
to Beverly Hills.
Michigan? Michigan?
Yes,
And you were a police officer there?
yes.
How long?
About 22 years, 22 years.
What rank did you achieve there?
What
Were you sergeant? When you left?
yes. Oh, when I left, I retired as a deputy.
Okay. And then you went, is that when you went to the Attorney General's office?
No,
Where'd you go?
the Department of Insurance.
Is that part of the state?
Yes.
And then how long were you there?
About a year.
Then where'd you go?
The Attorney General's office
How long have you been investigating with the Attorney General's office?
since October of 2022.
So October 22, so this is, you were fresh on the job when you got this case assigned to you, correct?
Yeah,
And I think you said, I remember the date, because I think it's the same date, 2022 before county act happened, but December 28th of 2022, is that when you started?
yes,
That's when you started this investigation.
yes,
You took it over from another investigator, correct?
yes,
Is that a Scott Cronin?
yes,
And Mr. Cronin he was an investigator with you.
yes.
He had a case. I think someone asked you a question about this in one of the voir years. Did he have the case as early as 2020, or was it 2021? The investigation was open to what occurred in December 14, 2020.
I know it wasn't 2020. I don't recall when he was assigned the case.
Do you know what started the investigation? Was it a tip? Was there something that started the investigation?
There was I know that there was an email that came in from Ms. Hoekstra over at the National.
Your Honor, I may just ask the witness to keep his voice up when he speaks.
I'm
directly
sorry.
to Mr. Bellotta, I have a hard time hearing.
Thank you.
Understood.
I apologize, my voice is a little weak today because I'm a little cold. And what types of cases did you investigate at the Department of Insurance? Were they insurance fraud typically?
Yes,
This case represents your first investigation involving the election laws, correct?
yeah,
Did you learn a lot about, for instance, the electoral process? In this case, I know I did.
Yeah.
Did you learn a lot about that?
yeah, sir.
Things that you didn't know?
Yes, sir.
But you didn't know what for instance, you didn't know what a duly elected elector meant when you first got the case, correct?
Yeah,
Yes, you did.
correct.
know?
Yeah, to clarify,
Sorry.
yes, correct.
See, it's my fault, Agent Shot, because I'm using a double negative. I know better.
Okay.
You would agree with me that you didn't know what a duly elected and qualified elector was when you first got this case.
That's correct.
And you learned that because you looked at the statute, you looked at what was required to become duly elected elector, correct?
Yeah,
You learned that, for instance, there had to be what's called a certificate of ascertainment that is certified by the governor, the executive of the state of Michigan, for these people to be duly elected, correct?
Yes.
And we heard testimony from Mr. Schwager yesterday, who's the general counsel for the secretary of the US Senate. Remember?
yes, I
And
remember this.
when I asked questions, he confirmed that without that certificate of ascertainment, when the governor declares the winner, is the party of the electors that are voting, their votes don't matter, right? They're legally insignificant, right?
Yes.
But you didn't know all of that before you got this case in December of 2022, correct?
Yeah.
Let me ask you, oh, why did investigator Cronin leave the case, if you know?
He was assigned, there was a new unit that opened up that he submitted interest. And so he was accepted into that new unit.
Do you feel, and I don't mean this in a flippant way, but do you feel like you got assigned this case as you were, that you got?
No, I don't know what the process is in terms of signing cases.
Now, let me talk to you about my client for a second. And I'll direct your attention to my client Rose, who's in the front row of the spectators wearing blue and white blouse. And I say blouse because I asked this I'm not sure. Blouse, and she's here today. You've met her before, haven't you?
Yes.
And you sat down with her and she came into proper with you for about 3 hours.
Yes.
Back 2023. Right?
Yes.
It was in May 22nd, 23, do you remember?
I don't recall the date.
That's okay. We don't need to know exactly. But she's, you know that she's, I'm not gonna say her age, but she's in her 80s, correct? Low 80s, I would say that. Low 80s, correct?
Yes.
Retired.
Yes.
She's a grandma.
I learned that from the proper.
Okay. And you know that she's not an attorney, right?
Not that I'm aware of.
You wouldn't expect that she would know what a duly elected qualified elector was any more than you would have before you got the case, correct?
Your Honor, I'm gonna object that calls for the witness to opine.
I'll rephrase it. I'll rephrase it.
Objection sustained.
Did anything in your investigation tell you that Rose Rook knew what a duly elected qualified elector was prior to? Did you find any evidence of that?
That's a specific question as to his investigation. Did he discover anything in his investigation? So I'll allow to
I want to hear
answer.
the objection. I'm excited to hear.
I haven't said anything yet. I know that's what I'm saying.
I know. Take your time. I'm confident in my question.
I found through my investigation that she had experience in local politics.
She worked in her local party Van Buren County. Do you know what Van Buren County is?
It's west side of the state.
Yeah. You know where Paw Paw is?
Yeah.
It's a little town of about 3,000 people, right?
I don't know the population.
You know it's a small town, right?
I believe it's a small town.
About an hour and change directly due west of here, right?
I don't know the distance. I know it's a southwest area of the state.
But you know, you agree that Rose Rook's not an attorney, correct?
That's correct.
And you agree that Rose Rook has never been a candidate, elector candidate or elector nominee. She's never been that before, correct?
I didn't find any evidence of that.
You didn't find any evidence that she had any particular knowledge of the electoral college process, did you?
I don't recall what knowledge she made.
Well, wouldn't that be important for you to know? Because aren't you saying in the prosecution, isn't what your investigation found is that these people, these elderly people who volunteered their time for the party, what you found is that they didn't have the sophistication that maybe you have now after you look at the case. Would you agree with that?
Well, they didn't talk to me about it. So I don't know.
Well, wait a minute. You've talked to several electors about this case, haven't you? Including my client.
Under proper, yes.
Yeah, but you heard what they had to say.
Yes, and
after you heard what they had to say, you eventually went and you got a warrant to get them all charged with 8 felonies, didn't you?
I swore to a warrant. Yes.
Okay, so what I'm going to ask you, and to maybe preclude some of the objections for hearsay or what have you, I'm not going to ask you anything that's going to elicit hearsay. I want to know why you decided to go. Was it July the 18th of 2023? Is that when you
Sounds about right.
swore to the affidavit? I want to know why you decided to do it after meeting my client, talking to Mr. Renner, who I know has testified before. I want to understand why you did that. So I'm just prefacing my questions down, okay? So one of the things you did is you applied for search warrants for, and I want to go through the different things you looked at. You looked at social media, we already talked about that, right? Facebook,
Yes,
and that's why you subpoenaed Meta.
I didn't subpoena.
I'm sorry, that's why you served the warrant on it, correct?
Yes,
And I know Meta owns Instagram. With these electors, they probably want Facebook users.
I don't recall that.
Is that what
Which
you
one they
found?
were more on?
Oh, well, what you've discussed so far has been of the social media has been Facebook, correct?
Yes.
Now, you talked a minute ago about a number of emails that happened between the attorney Ken Cheeseborough, however you pronounce his name. We'll call him Attorney Cheeseborough. He sent some emails to Miss Sheridan, correct?
Yeah.
And you testified that those contained attachments that ended up apparently being what turned out to be government's People's Exhibit 11, correct?
Yes.
At least she was provided a copy of a draft of that, correct? It appears.
Yes.
On that email chain, well, first of all, do you know if Rose even had ever met Ms. Sheridan prior to December 14, 2020?
I don't recall.
Would it be consistent with your investigation that my client did not know Miriam Sheridan until she met her on the day that she signed the document?
I
Would that be
don't,
consistent? If that were true, would that be consistent with your investigation?
I'm not sure what you're asking.
I'm asking you, did you find any other evidence that Rose Rook was communicating with Ms. Sheridan, had a friendship or relationship with her prior to December 14th?
I don't recall.
Is there something you can look at to do this? Is there something that you could look at? Because it's important, you know, my client is on facing 8 felony charges.
Understood.
So I need to know.
Is there anything that will refresh your recollection?
Probably the proper report, the
Do
interview
you have that handy?
would be on my computer.
We need a couple
I
moments.
do, I'm sorry.
You don't have to apologize, that's what we're here for. So, 5 minutes. You can get your.
Okay.
Because they're easier to do a playlist.
Oh, good mix it.
Really?
They're mixed.
I don't think that's true, but okay. That they're easier. I
Oh,
think
that people love the
I don't
records,
know,
I
but
know.
there, it's like the vinyl is making them come back.
Yeah, that.
you can't beat the sound quality and all that. So.
And that's still why I have my Led Zeppelin Stairway to Heaven in immaculate condition. Oh my goodness. You want to buy it?
No. I don't have the right flavor.
Oh,
Okay, back on the record.
Your Honor, before we proceed further, I think it's a little bit time consuming for the witness to continue to have to go back and forth to the computer based on my demand to have access to the computer and what he does. If the prosecutor would stipulate and the witness would promise that the witness identify what documents he is actually looking at to refresh his memory advise the court of those documents and then make them available to prosecution. That way, we're not continuously going back and forth, putting the contents of his computer in jeopardy. I just want to know what is it he's looking at when he does refresh his memory. So I don't know if that helps or not, but I would stipulate to that agreement that as long as the witness is willing to advise us of every document he reviews. So that's.
I think it's reasonable. I stated yesterday that I wouldn't, under no circumstances, at least not the ones presented in this case, grant you access or complete access to his computer based on him refreshing his recollection. It's a case that has probably tens of thousands of pages of evidence and videos and such. He can't haul all that information into the courtroom. And so there has to be a way or a mechanism for him to be able to refresh his recollection. I do think that you should be advised what he is using to refresh his recollection. So I will require that.
And as a response to that, Your Honor, the people obviously have no objection to that. It's upon information and belief, and obviously this is assuming that Agent Shock will need to refresh his memory, that any document that he's using to refresh his recollection has been previously provided, but as the court has ordered, Agent Shock will identify what document he is using to refresh his memory.
Very good. Okay. And so did you have to take
No, I
it?
need to get the exhibit, sorry.
Oh, you can get it.
22.
I think the court has it.
Okay.
They're all in here. And so your question was what a document was just used or just the stipulation moving
The
forward?
stipulation, I just
Okay.
wanted to stipulate it that for the purposes of prelim,
That stipulation has been noted.
Or have you had a chance to refresh your memory as to whether you had any evidence that this Brooke, my client, knew Ms. Sheridan or had any communications with her prior to December 14th?
Yeah.
What is your answer?
Your Honor, I'm going to object. The answer to that question would be derived from hearsay.
Your Honor, again, I'm not introducing anything here for the truth of anything. I'm introducing
It's
to
not
understand
here.
why he went and asked for a warrant.
It's not being admitted for the truth of the matter asserted. What would it be against your client anyways, but what is it being admitted for?
I'm asking him whether, well, I'll rephrase my question. I'll withdraw that question.
Okay, it's
And
withdrawn.
I'll just ask this, because I didn't ask the question for the record. I didn't ask about it. I didn't ask, what did my client say? My question was, did you find any other evidence, or any admissible evidence or non-admissible evidence? Any evidence that this lady in the front row, in the Rose Row, knew Mary
Or
Sheridan?
had a relationship with her, which was the previous question.
Do you have any
Okay,
evidence?
And the people's objection was that the response would come from hearsay.
objections overruled. You can answer
Any
it.
evidence tying these two together before the
It's not being offered for the truth of the matter asserted.
Then
I
I would-
expect his answer to be no, Judge.
Then I would
No is
object
not
to
hearsay.
the relevance then.
It's very relevant.
You can respond as to why you believe it's relevant. I don't see how whether or not they had a relationship goes to
She just,
the conspiracy, so it's definitely not being offered for that, so.
well, Judge, she just introduced evidence for the first time, and I didn't know about this, I'm not saying it wasn't even discovered. But I'm saying, the first time we hear that an elector was given a pre-December 14th, 2020 version of what ultimately these people signed. And it's the first time I've heard any connection between Penn Chesbro and any of the electors. So my question is, it's important to know whether my client was involved with Ms. Sheridan or this document that was going back and forth between her and Kenneth Chesbro. So it's very relevant. I don't think that's proper objection in this case.
I don't know, maybe his defense is that she doesn't know him, she never,
Yeah, she doesn't, she's not.
I don't know, I couldn't speak to it, but I'm gonna allow him to answer it.
Well, man, just have one response.
You may.
Well, then the answer is being used for the truth of the matter asserted. Then if the whole point is whether or not there was a relationship between Ms. Rook and Ms. Sheridan, And in order for the witness to answer that question, he would.
A
be
prior
deriving-
relationship though.
Yeah, I'm
Right,
asking,
he would be
You don't
deriving
need to
that
have a
from
prior
hearsay.
relationship. Their relationship could have began at the time that an email was exchanged. I don't know.
so if the answer is no, that can never be hearsay. I'm asking, is there any evidence?
She's saying that the evidence derived from hearsay, is what she said, that the response would derive from hearsay.
Well, it may not be what she said. I'm asking for positive evidence. Did anyone come and say they had a relationship? Is there any evidence?
It could be, you know, through his search warrants. He saw where they were communicating prior to. I don't know where he got it from.
So it's not-
I'm gonna allow him to answer it.
It's just not hearsay. Was there any evidence that you found from any source, social media? Did you get phone records from people too?
Yes.
Phone records, you didn't have a wiretap, I assume, because you don't have that power in the state of Michigan. There was no federal investigation in the states, correct?
I don't know if there was or there wasn't.
Well, you know that we'll get to this later, but you know that the federal government declined to be involved in this prosecution, correct?
The January 6th Select Committee in the Department of Justice.
I'm not talking about that, sir. I'm talking about the federal government in Michigan, U.S. Attorney's offices. They did not get involved in this investigation, correct?
Objection, relevance.
It's irrelevant.
I'm asking them if there were any wiretaps, that's all. I'm asking them.
You're asking, were there any wiretaps?
Yes, I'm confirming that there were no wiretaps.
Well, it's irrelevant.
Well, I want to know if.
I know you want to know, but we want to know the relevant.
The relevance is I'm eliminating all the sources where he could have found information connecting my client to this new evidence showing that a connection between Ken Chesborough and Miriam Sheridan. I want to just make sure there's no evidence out there that I don't know of that connects my client to to Sheridan. That's what I was doing.
Okay.
So I don't understand that. I don't understand the objection.
I
No,
objected
it's
to
certainly
the
not a legal
question
basis.
that the federal government declined to get involved in this
Well, I'll ask
prosecution.
questions about
That,
that later. I'll ask that later. I'll move past that.
Okay, you're gonna withdraw that question as to the federal government?
Yes, I'll forget the
Okay.
wiretaps. I
Sounds
know
good.
there weren't. There were no wiretaps, correct? No,
I did not conduct any wiretaps.
please listen to my question. That you know, of.
That's
there were no wiretaps done, that you know. of.
that I know
Okay, I know you can't conduct a wiretap. You're a state
of. Okay,
official.
then
You can't do it.
I'm not aware of any
That's what I
wiretaps.
asked.
but- Okay.
So no evidence that you found connecting those two. Did connecting Miriam Sheridan and Rosewood. We've had no evidence connecting the two of those prior to December 14th, 2020, correct?
So through my interview with your client, Mrs. Rhodes, they did communicate through telegram, according to my report.
After.
Doesn't specify when the date is. And then also from the report, you touched on if she knew she was what an elector
No,
meant to
please just
be.
answer my questions. I'm not asking for you to
Okay.
go on.
Oh, I wasn't able to answer that one earlier, so
My question is, you don't have any evidence connecting the two of them before December 14th, 2020. You just made a reference to something that the prosecutor objected to, which was hearsay statements from my client. But even those statements, you say you cannot source those to prior to December 14th, 2020, correct?
I don't know when they communicated.
Because you didn't ask for the question, correct?
Your Honor, I'd ask that the witness be allowed to finish his answer.
You said you didn't know.
Was there any more to that answer, sir?
I don't know when they communicated. I don't recall if I asked her. It was through telegram according to my report.
Okay, so your best answer is, let me ask this question. Do you have any evidence? Can you give me any evidence besides the fact that at some point Rosewood began speaking to Miriam Sheridan based on your review of the property? Is there any other evidence connecting those two prior to December 14th, 2020 you found?
I don't recall that.
You just say there wasn't, just don't recall. Why do you have to say you don't recall, sir?
Because I'm under oath, I'm testifying to the truth.
So you don't know the evidence in your own case?
If I don't have an answer that is specific that I recall, then that's gonna be my response. Telling the truth is very important to me, sir. So,
Well, we're gonna talk about that in a little bit.
okay.
But let me just ask you this thing. So your answer is that you don't recall. So you, right now, as you sit here today, you can't provide any evidence showing that Rose Rook communicated with Gary Sheridan prior to December 14th? Yes or no? Yes or no?
They communicated.
No, sorry. Prior to December 14th, do you have any specific evidence showing they communicated prior to December 14th, 2020? I don't know why this is taking so long to get an answer.
I'm trying to provide an answer, sir.
Are you?
Yes,
What's your answer?
I don't know.
And the answer is that you don't have any evidence. Or do you think you have evidence you just don't remember that's sitting around?
I have evidence that they communicated. I don't know when they communicated.
Yeah, you already talked about that. I'm asking, do you have any other evidence that they talked before or communicated in any way before December 20?
I think he just answered that. He doesn't know.
And then the answer is he doesn't have any evidence.
That's not the answer if he doesn't know. He doesn't
You don't
know.
know, so you may have evidence, you
Yes.
just don't know.
I don't know when they communicated. I've already stated that they communicated in Telegram.
Well, let me try to ask you a more specific question. Besides this proper statement you're talking about, where you don't know when they started communicating, well, put that aside. Is there any other evidence that you can think of as you sit here today, under oath, trying to tell the truth? What other evidence is there that they were communicating before December 14th? That's what I'm.
I can't think of any other.
Can't think of it. Thank you.
Okay. All right. So long.
All right, we'll move on. Okay, now you talked about a post, yes, or I think you called it a post, but I want to show you exhibit 22. People's exhibit 22, and direct your attention to the highlighted portions on the third page of the exhibit. Please read that to yourself, and I want to ask you about that. Okay, I want to take you through this for a second. So this is, no one's contesting that that isn't Rose, that's Rose Rook's Facebook account. So you did a search warrant and you got a return, as you called it. And that included Rose Rook's information from her Facebook account, is that correct?
Yes.
Okay, and you saw a message that apparently the Attorney General thought was important, highlighted on that page. Do you see the highlighted portion of that page?
Yes.
And is it a, do you know if that's a post? It was called a post yesterday. Is it a messenger message? Do you know? Is it iMessage or a Facebook Messenger message? Do you know what it is?
Based on looking at
Yeah.
this, I don't know.
Okay, but it looks like she was asked a question, correct? That started this message? A question she was asked by someone named Shirley Ann Amos.
Yes.
And Your Honor has a copy of exhibit 22.
I do not. I think you have, or he has the copy.
Did you introduce me?
Yeah. It's been admitted,
Okay, you
but
don't
he's
have it.
using the exhibit.
I don't have a copy. I'll give you a copy.
No worries.
I kind of wanted to.
I'm gonna review all of this
All right.
anyways.
In any event, though, it's a message from a Shirley Ann Amos. It's a question. Did you get to vote today? See that?
Yes.
And do you see that the universal, the unified time has 4:31?
Yes.
And you know that that's 5 hours in the future, so it would have been at 11:30 p.m. roughly Eastern Standard Time, correct?
Yes.
And that was a question that was asked by Shirley Ann Amos to Rose Rook on the evening of the day that they voted, that they signed this document, correct?
Yes.
And Ms. Rook doesn't respond right away, correct? 8 hours pass. If you look at the time system.
Yeah, I'm looking at the time, yeah.
So about 8 hours later, and I'll just do the conversion for you, you can agree with me, at about 7:22 a.m.
Yes.
Agree with that?
Yes.
On the next day, which is the day after they signed, December 15, 2020, correct? So
Yeah.
in the morning, Ms. Rook gets back and answers the question, and she says, what if you can read the answer, what does she say?
Her first response?
Yeah.
Okay. Yes, I did, but we got slapped in the face by Shirky and Chatfield.
I'm sorry. Can you say that again? Read that
Yes,
again?
yes. Yes, I did, but we got slapped in the face by Shirky and Chatfield.
Now, in your investigation, are you aware of something that happened later that day in the afternoon? As you mentioned, Mike Shirky has been mentioned, not only in that, but of course these proceedings. So what I want to know is, Are you aware of a press release that Mr. Shirkey put out in the afternoon of December 14th, 2020?
Yes.
And in that press release, he said,
Objection, hearsay.
no, Your Honor, it's not coming from the truth. It's coming from what people thought and knew. This whole case depends on specific intention of fraud. So what people hear in the ether and in the media goes to their mindset. So the prosecution is trying to argue, these people knew that there was no fraud, yet they went ahead and signed the document. My question goes to why Rose Rook would say these things about Shirkey, that he slapped us in the face, and explain the timing of when Shirkey made the statements. It all goes to the intent.
Repeat your question.
My question, well, I haven't read that. I don't remember exactly.
His question started with,
I'll
and
rephrase
then
it.
Mike
I'm gonna tell
Shirkey
them.
said, and I objected. May I respond to
Yes.
his response? The crux of the matter is there's nothing on this record that will establish that whatever press release was issued on December 14th or the 15th by Mike Shirkey was viewed or heard by Rose Rook. So effect on the listener, there's no foundation for that.
Well, is there a stipulation that Rose Rook did not know of Shirkey's commencement at the time that she signed the document? Well, isn't that what you just said, that it's irrelevant because
I did not say that. I said there was no foundation.
There's no foundation.
he's the foundation. I'm asking if this investigation, he found these things happen.
Yeah, but
She
I
asked all day long,
think she
what-
objected to hearsay because of your question asked or was phrased, asking what someone else
Yes,
said.
yes, and it's not to prove the truth. But what you have, you know this, Judge, you've said this over and over again, it doesn't go to the truth. I'm not introducing it to show that there was no fraud. I'm introducing it to show that this statement was made. The fact that it was made is relevant because she, the prosecution is trying to insinuate that my client knew about the Shirkey comments, and yet she voted anyway, because she's talking about Shirkey slapping us in the face.
So how does this not go to the truth?
Because it doesn't matter, but think about the out of court statement, it's Shirkey saying, we have not found any fraud. I'm not introducing it to show they haven't found any fraud, I'm introducing it to show that he announced that he's not looking anymore, and therefore they shouldn't have signed this document. So I'm introducing it to show what was in the public domain at the time these people are, on December 14th, the day this happened. I don't understand how that can't be relevant.
The objection was not that it wasn't
Why don't you
relevant.
tell it hearsay if it's not coming in for the truth?
It is. It is coming in for the truth.
No, because I'm not trying to prove what Shirkey said. It would be coming in for
So
the
what
truth.
purpose are you bringing it for? Is it the fact on the list of what
That
you
should
bring?
know that Shirkey indicated that the Republican Party is not going to fight the election results. That's very important.
Objections sustained. You do not need to answer that question. You didn't provide me a sufficient basis.
That it's not for the truth.
Exactly.
Okay. Was there an announcement made at some point by Shirkey that day? I'm not going to ask you specifically what was said. Was there an announcement made that you're aware of?
An announcement about the election.
No, just about an investigation.
I
Maybe you're not aware of it. Are you aware of what?
There was a Shirkey and Chatfield made an announcement about the election and whether or not that there was fraud.
That was on the 14th?
Yes.
Okay, and they concluded that there wasn't fraud. That was their point of view, right?
Objection, Your Honor. Hearsay.
I'm not bringing it in to show that there was no fraud. I'm bringing to show their conclusion.
How's that not hearsay?
You kind of asked two questions at the same time. You finished the question in between her objection. You want to know their
I
point
want
of
to know,
view.
I want to know whether or not the word was put out that they weren't going to be challenging the election. If the word is put out there, I'm not introducing it to show what was said is true. That would be hearsay. If I was introducing it to say, Mike Shirkey said the light was red, and that was relevant to my proceeding, that would be hearsay. I'm not introducing it. I'm introducing it to show that the Mike Shirkey, who's the speaker of the Senate Majority Leader, said, we're not challenging the Senate. He's putting the word out there that they're not going to be fighting. So how is that hearsay? I'm not introducing it to show that there was no fraud. In fact, it would help my client if there was fraud. So I don't understand how that.
It would help your client if there was fraud, you said?
No, I'm saying I'm not trying to prove that there wasn't fraud. or there was, it doesn't matter. The fact is, Shirky says there wasn't fraud. That affected how people acted. And that caused Rose Rook to write that text or that message. I have to explain that. Otherwise, who knows what she's talking about? Maybe it could mean that she's talking to Shirky before this time. I need to explore why she would have said that, Judge.
Okay.
Your Honor.
You're gonna ask this witness why she would have said that?
I'm asking the witness what was in the public domain. Okay, it would be just like asking, were you aware of this case was pending? That's what you're saying.
I can agree to that.
So I'm just asking, was that out there for people to consume?
Was that in the public
That's what
domain?
I'm asking.
Okay,
Your
I
Honor,
wanted to respond.
I believe counsel said that what he's trying to elicit these statements for is effect on the listener, and the listener being Ms. Rose Rook.
No, everybody.
May I say it? First of all, there's nothing on this record that would establish that Ms. Rook heard these statements. And two, this witness cannot testify to how those statements would have affected Ms. Rook. So we've got foundational problems here. I'm still talking. And that's above the fact that it's still hearsay.
I don't understand how it's hearsay to ask somebody something was in the public domain that could have affected what you're doing. That's not hearsay.
Your question is whether or not there's something in the public domain. I will allow him to ask that because we've already had testimony about what was in the public domain and what these even what your investigator or the AG's investigator may or may not have been aware of when he did his investigation. So as to what was in the public domain, I'll allow him to answer that question.
Okay. And for the record, I've listened to all the other testimony. There's tons of hearsay that we allowed. Listen, but anyway, that's either here or there. It was out in the.
You gotta object.
No, I wasn't a part of those. So
Oh,
what?
okay, got it.
You would agree that it was in the public domain at some point on December 14th, 2020, that Shirky did not think there was any fraud, correct?
Yes.
That got out there for people to see, okay? But my question to you is, you have no evidence that Ms. Rook heard that prior to her signing, or any of the electors had heard that prior to signing people's exhibit 11. You understand my question?
I think so. I have evidence to show that they were following media reports and things like that.
Okay. Go on, keep going. I'm gonna cut you off.
Specific to your
Unless I
client.
have to.
No.
So nothing specific to my client to show that she would have known that. That's it. Correct. Thank you. Oh, and back to the email between Ms. Sheridan and Mr. Chesbrough. Did you had the emails by way of a search warrant, right? Did you get the emails between Mr. Oh, no, you got them from him, I'm sorry, my bad. Mr. Chesbrough gave you the emails, correct?
Yes, sure.
But you have no reason to doubt that they're not authentic. You have no reason to doubt, correct?
That's correct.
And were you able to look at did you investigate whether Ms. Sheridan shared that document? I think you said she received it on December the 10th, 2020, is that right?
Yes.
She received that document from Chesbrough, correct?
Yes,
And do you know if she forwarded that document or sent it to anybody else? Did you check?
I do not.
But didn't you get their emails? Get Ms. Sheridan's emails by a search warrant?
No, sir.
I think that would have been an important thing to find out whether Ms. Sheridan shared that.
The Kenneth Chesbrough email? Yes,
And you didn't check for that?
I did not.
Is there a reason why you didn't check?
Because I didn't have that information at the time. I received that information December
23?
6th of 23.
Understood.
Yes, sir.
And since December 23, when you had that, I think you said a 3-hour interview, a long interview with Chesbrough, since that time, you haven't tried to get their emails of Ms. Sheridan or the other electors?
No,
Why not? Is there a reason? Just that it was important?
I don't have a reason off the top of my head.
Okay. All right, now back to the Rose Rook messages between her and Stamos. So, question, we already talked about that. She said, she's asked if she voted today. The next morning, on the 15th, she says, yes. And then, can you read that again? What her answer again?
Yes, it says, yes, I did, but we got slapped in the face by Shirky and Chatfield.
Now, do you, and that was the next day. By the time that she wrote that email, sorry, or that message, whatever it was, by the time Ms. Rook wrote that message on December the 15th of 2020, Mr. Shirky had already made that, put into the public domain, what we talked about earlier, that he didn't find it, that committee he was working with didn't find fraud, right?
Yes.
At least not fraud enough to overturn the election, correct?
Yes.
Now, in this exchange here, does Rose Rook, she doesn't say anything about fooling anybody or cheating anyone or defrauding anyone in the text, in the message?
No, sir.
He doesn't say that she hopes that what they signed will fool Mike Pence in the Senate. She doesn't say that, correct?
Correct.
And she doesn't say that she hopes that it replaces the Democratic slate, even though the election hasn't been reversed. She doesn't say that, correct?
Correct.
Now, from your review of all the documents, how many search warrants did you serve for documents?
I don't recall how
More than
many.
10?
Yes, more than 10.
Oh, so you got a ton of material, as you know, from the discovery, correct?
Yes, sir.
And in any of that material, you reviewed, obviously you reviewed everything that you got from your search warrants, correct?
Yes.
And from all those documents, did you ever find any communications between Rose Rook and Rudy Giuliani?
No.
That would have been something if you saw that you would catch your attention, wouldn't it?
Yes.
Same question with Kenneth Chesborough. Any communications between Rose?
No, I did not find it.
Sean Flynn, the Trump attorney that was working out of the Republican headquarters on Seymour Street in this town?
No.
No. What about Mike Roman? You know who that is?
Yes.
Who is Mike Roman?
He worked for the Trump campaign. Trying to think of his direct or what his title was at the time. It slips my mind at this point.
And your investigation found that Ms. Rook, she wasn't communicating with the top officials at the Michigan Republican Party either, was she? That you found?
No, sir.
So you didn't find any messages between her and Laura Katz, for instance, the chair at the time of the Michigan Republican Party, correct? You didn't find any communications with me, Sean Maddox, the co-chair of the party, of the Michigan Republican Party?
No.
You didn't find any messages between Ms. Rook and Kathy Burden, who was a member of the National Republican Party? Same question as to Myra Rodriguez.
Correct.
Okay. And you don't have any evidence that Ms. Rook, when she showed up on the morning of December 14, 2020, you have no evidence that she even knew any of the other electors there that day. Okay. You did know that she volunteered in her district out in Paw Paw, correct?
She has some experience after reviewing my report. I think it goes back to 2008. What she told with the Republican Party.
You talked about local volunteering, did you?
I believe so, yeah.
So you said something yesterday. You said you started this investigation, but you said this before, because you're like, you focused on the document. And the document you focused on, you have equals 11. I would ask to approach, but I'm too close. I can just reach. Permission to reach. Permission to reach. All right. So showing you exhibit equals 11. You focused on this document, correct? Well, that was the first thing you did in your investigation, right?
Yeah.
And you knew when you started investigating kind of what kind of crimes you were thinking you might find, correct?
At first, I wasn't sure. I was just trying to review all the material.
Right, but at some point because you used to work in investigating fraud, didn't you? You were a fraud investigator in the auto insurance section.
Yes,
So you're familiar with fraud, correct?
yes,
How many fraud cases have you investigated? In your tenure? More than 10?
yes,
More than 20?
yes,
Okay, so you're familiar with how to investigate a fraud case, right?
yes,
Okay, and you know when you're investigating a fraud case, that fraud requires you find evidence of something called intent to defraud. You've heard that before, right?
yes,
And so your investigation was looking for intent to defraud, correct?
yes.
All right, I'm talking about that in a sec, but let me ask you about this document. So if you look at the second page, well, the first page is a memo explaining what the document is. Would you agree with that?
Yes,
And the second page is the first page of the actual document itself, correct?
yes,
All right, and that document states, and you heard the testimony, you heard my cross-examination of Dan Schwager yesterday up from the Senate. You heard that?
yes,
And you heard him say, when I asked him what's false about this, he said, being duly elected and qualified electors. See that? He
yes,
said that those are the things that he thought were not true of the document that he got when he got this document sent to him, to his office, right?
yes,
So would you agree with me? And you've heard testimony, by the way, that from several witnesses, that there was only one document that they saw when they signed. I have an exhibit B. I don't know if you would stipulate to its submission. It's just a page of this. I believe Mr. You have an objection to that?
You want to read the foundation first?
Yeah. You recognize defense exhibit B?
yes.
What is it?
So signature page, with the date 14th of December 2020.
Does it appear to be match the page 3 of People's Exhibit 11?
Yes,
Move to introduce.
No objection.
What number is it?
That's defense exhibit B, Your Honor, B as in boy.
Admitted.
So you heard testimony, sir, that this is all the electors saw that day, on December 14th.
I'm
That you
gonna,
learned that in the investigation.
there's been no testimony on this record that the electors have said that that's all they saw.
Well, you heard testimony in the other, I'm asking about his investigation, Judge. Again,
Yeah, well, let's be clear. You have testimony where?
you did testimony in this case, interviews in this case.
Right.
Who?
Your question is your testimony that that's all the electors saw.
Yes, I'm asking him, my ultimate question is gonna be, and I'm trying to find out why he ended up going on July 18th and getting a warrant. So
I'm not trying to figure out where you're going.
Yeah.
I'm trying to figure out your question. Your question is if he heard testimony, that I don't recall any testimony on
I'll
this.
rephrase my question.
Okay, because there was no testimony on this record for that.
No, but I'm asking about his investigation, not this. record.
Okay, so not necessarily testimony.
Well, there
but-
was testimony on another matter, and that's part of his investigation, right? You sat through the testimony on the first group, correct?
yes,
And you took notes?
Has the court made a ruling? On my objection?
Well, no, I was making a ruling on it now. He's talking about testimony in the previous set of,
Let me rephrase.
is that what you're talking about?
Yes, but it's also his investigation, because he also interviewed the same people who testified, so it's.
Well,
more
no,
than
your
just
question was testimony. And so whose testimony are you referencing? That he heard?
On exam that.
That- Okay, so you're asking if he heard testimony from Tony Zambit on the previous, whether or not that was all they heard? Is that your
I
question?
withdrew my question. I'm gonna try
Okay,
again.
well, then it's with John.
Thank you.
Your investigation, it was important for you to know what these 16 people intended to do by signing their name to this document, correct? That was important to your investigation. Do you agree?
Yes.
And one thing that would be really important to your investigation is to know whether or not what they signed, what they saw on the table was just this page, instead of that page, with this page that comes first, that says, we are the duly elected and qualified electors. The same thing that Mr. Schwager said was the false part. Remember that?
Yes.
So my question is, if they only saw this, they wouldn't know that they were claiming to be duly elected, correct?
Objection, Your Honor, cause for speculation.
Unless somebody told them.
There's an objection, cause for speculation. Did you want to respond to the
No,
objection?
I'll withdraw the question. Right. Assume this hypothetical. All the electors saw the day they signed, December 14th. And you have had, I'll try to ask this question again. You have, your investigation has revealed that some electors did not see other pages, correct?
Your Honor, I'm gonna object because that is, the answer is going to be, may I make my objection? The answer is going to be derived from hearsay unless the proper foundation is laid.
Well, his question was, during his investigation, did he determine that some of the electors did not see anything other than this page? Is that his question?
Yes.
Well,
Here's the problem.
objections overruled. You can answer it.
Can I just point out the problem that I see? Last time she waited till the end of the month. Okay, I had, okay, maybe I'm wrong. I think she waited till after these other people testified. I want to ask about what Renner said. I want to ask what these other people said, and how it affected his investigation. If I get an objection every time for hearsay, this is going to take forever. I just want to ask him about how the fact that these people are saying that they didn't see the other pages, that affected his investigation.
Right, but you're asking if during his investigation, and so I've allowed that question.
Okay.
He can answer it.
I forgot it, but during your investigation, did you find evidence that the electors only saw one page?
I found evidence that electors, through statements or witnesses or themselves, said that there was multiple documents. Did find evidence from one of the electors that said that she saw the one page.
Right, but Mr. Renner only saw one page too, right?
I don't recall what Mr. Renner's testimony.
Okay, we'll wait for his testimony. Now,
And just for the record, you can always recall him. as
yeah,
your
I didn't want to
witness.
do that. That's why I was trying to do it.
It's your case.
Well, I appreciate you saying that, but I've had other judges and state district judges say you're not recalling, so you're not recalling it. So you should have asked before. So I just haven't.
This is her case in chief. I can't tell you that you can't call.
I know
your
you
witness
shouldn't be able to, but I'm saying
when
some
I asked
judges
the
have said
defense.
that.
Well, I'm telling you that you have the right to recall.
I appreciate that. So, you would agree, would you not, that if the electors who signed this document only saw this page and no one told them about this first page, where they say that they're the duly elected qualified electors, then they wouldn't know what they were signing, if they were making a false statement. Do you agree with that?
As objected, as soon as facts not of evidence and it calls for speculation.
This is the same question that he forgot about him asking, which was if hypothetically he were to assume that this was all that the electors saw, whether or not that
They were
would
making a false statement.
Well, it was, if that's all they saw, and he also added, they weren't told about the first page, which assumes facts not in evidence.
Well, yes, so she's asking to assume that. It's a hypothetical. He's trying to, I guess, gather how he would have formulated his investigation. Is that your goal? What is the?
Yes, I'm showing that he knew, well, I don't want to make my argument, but I'm showing that,
Was a hypothetical, that doesn't show that he knows, that's.
no, I'm trying to show that the investigators and the AG knew that these people didn't know, think they were doing. it
You're,
wrong.
I think it calls for speculation still.
well, it is, if it's a hypothetical, it would cause speculation, because you're
asking,
not
but-
providing that he did, that's in fact information he did know, if.
I
he knew
expect that to be I expect it to be the evidence in this case, based on the witnesses that I read, that I listened to last time, so. I can
Okay.
recall him, or I could just ask him a simple question. You would agree, I think everybody in this room would agree, but I just wanted to ask him that question. Would you
Well,
agree?
hypothetically, if that was the case, I'll let him answer it hypothetically. I don't know that that'll be what the testimony yields in this case, but we'll see.
Hypothetically, yes.
So, does you agree, I guess I could ask you this way, you agree that there's nothing on this page? Again, page 3, that's false on its face. Knowing now what you know about what it means to be a duly qualified elector. Right? Knowing that,
Yeah.
is there anything on that page that's false that you can find?
No.
Okay. And you don't know whether or not Rose Rook saw the page before that makes the statement of being a duly qualified. You don't know that, right?
I don't recall what her statements were to me.
Are we gonna do this every time? I mean, is there any evidence that you have specific evidence that she saw the first page?
I don't recall what her statements were in the proffer.
No, I'm sorry, I'm gonna object to this witness not answering my question. I keep asking this, is there any evidence? There isn't. I don't recall, I gotta go look at my proper report. That's not appropriate.
How would you want me to rule on your objection for him not answering the question?
Just tell him to answer the question.
He said he doesn't know. I can't make him know.
You don't know.
You can ask him if there's anything that will refresh his recollection, but you can't
I
make
don't want,
someone
I'm
know.
trying to avoid that.
Well, unfortunately, we can't avoid that, so.
Is there anything? I don't have it. Is there anything that you could look at? That would refresh your memory? If you have any other evidence showing that Rose Rook, look, that first page of this document, which is really the second page of this.
By that proffer report, that
Yeah.
interview.
Right, but I was at the proffer, right?
Yes,
And I'm asking you the question, you have no evidence that she saw this page, correct? Didn't she tell you she didn't see the page? I mean, you want me to ask that
Objection,
question?
Your
I'm
Honor,
trying to avoid it.
hearsay.
I'm trying not to ask that question. I'm trying to ask, you have no evidence of it.
Your objection is to hearsay as to what his client said?
Well, the question, didn't she tell you,
Well,
insert the rest, it's
He's,
hearsay.
he's implying that maybe she did say she saw it. I know she didn't, I was there, but I'm asking this witness, I can't be a witness, I'm asking this witness, do you have any evidence at all that she saw this page?
Well, with all due respect, the witness is not implying that. He says he doesn't recall what the
He said he
what the
didn't
defendant
recall.
said.
And you're trying to get around him having to refresh his recollection, but it's not,
Yeah. All right,
it's not
let's take
going
a
the way
break.
you want it to go.
Okay,
Is there anything that would refresh your recollection, Agent Sharp?
yes, Your Honor, the proper report, the interview of Mrs. Ruff.
Would you like him to refresh his recollection?
and I apologize to the court.
You don't have to apologize. This is what we're here for.
And I'll be referring to that report interview of
Okay.
Mrs. Ruff.
Okay, you have a
I'll
couple
just
minutes.
confirm that.
Hearsay.
I would just ask that he confirm what he looked at. He said what he's gonna look at, which is fine. I just want to, when he's done. Well, I did look at this report and I had to look at that too. That's all I wanted to know was what he.
I want to respond to the hearsay objection, which is what I made, because I'm not asking what she said. I'm asking this witness, do you have any evidence? I expect it to be no.
That was the question. He said he doesn't know, so he's got to.
And now we can find out if he knows. I'm not asking him to come back and say what she said. So you know, I'm not asking for hearsay.
I understand your question, but just because you think your question doesn't ask for hearsay, his answer, he says his answer is going to come from hearsay.
No, his answer is, I don't, it's gonna be either yes, I have evidence, or no, I don't have evidence. That's his answer. Yes or no. It's a yes or no.
Counsel.
Can we take a break to go to the bathroom?
Well, we're gonna get a break anyway, so he can refresh his recollection.
Thank you.
Off the record.
Thank you.
Okay, from the search.
All stuff that you got right now.
Yes, okay. Yeah, I can't.
Yeah, I'm only asking.
Okay, the highlight. Yeah, yeah,
You look to the office.
yes.
That's all. Thank you.
Oh.
I always get nervous when somebody starts looking at the court rules. What are those things? I don't know.
Madonna, are you saying that this is not on the stuff regarding you?
I am not saying that.
Okay. Hey, what she doesn't know is I have this. You guys don't need to get one of these. Michigan rules are the same. Says them all.
You got a laminated card?
It's not
Wow.
laminated, but. I don't
Well,
use it
looks
that much,
pretty
but I
sturdy.
love it. I don't sleep with it under my pillow.
See, Michael, I says,
Are you ready to go back on the record?
Yeah, I'll try.
Okay, back on the record. And Aiken Sharp was refreshing his recollection.
Go back.
Asked you a question.
Yes, yes. Took a break so you could check whether or not you had any evidence in the case that Roserook saw the preceding page, the preceding the signature page of what she signed. And we had a conversation, but we not prior to right now, you testified
Yes,
during the break. You said that you reviewed the proffer of Ms. Rook. Correct? Is that what you looked at?
my proper report that was written from the interview of Mrs. Wood.
Understood. Okay, and you found that there were, so you have information that there might have been multiple pages, but it was the same signature. Is that what you found in your investigation?
Yes,
And it wasn't only Ms. Rook who said that. Also, didn't Tony Zambit say that in your investigation, that there were only a signature page, multiple copies of a signature page?
Here's the.
Offered to go to his investigation, and why, if he knew this, why would he go ahead and try to charge my client and the other people? Why didn't he?
It's not being offered the truth for the matter, sir. You're saying it's being offered to show what he did, why he continued his investigation?
Yeah, why didn't you just say, hey, there's no evidence here that these people saw this other page, they just saw a signature page, because he has two witnesses that are telling him. And I'm asking him, did that affect your investigation?
Don't think that's a correct recitation of Tony Sammett's recitation.
Wait, his question was asking if that's what Tony Zammit said, so
Well,
if I allow it,
still
he'll
object-
explain, he'll be able to.
I'm still objecting to that as hearsay.
Yeah, he's saying it's not being offered for the truth of the matter asserted, that he's offering it to show how, if that statement was made, how it affected him.
Yeah, why would he go ahead and get a warrant? If he knows that these people may not have even seen it.
Okay, the objections are overruled. You can answer it.
You had information from Mr. Zammit that he saw, I think he said in triplicate, 3 copies of a signature page. Do you know that? Did you have that information? I was asking that.
I don't recall what Mr. Zammit said
Okay.
relative to a signature page.
Okay. All right, well, you already answered the question that you have no evidence that Ms. Rook saw that signature page.
I saw that she saw, or I read in my report that she saw 2 documents that where she signed.
Right, but you
That
told
she
me
signed.
during the break that she said that those were signature pages, right?
Yes,
So the 2 pages that were signature pages, not the preceding page, correct? With all the words on it, talking about being duly elected.
no,
Okay, thank you. She didn't see that page. And as far as you know, from your investigation, you can't prove that she saw that page, correct?
yes.
Thank you. All right. Let me ask you about a different topic. We already talked about what it means to be duly elected. Talked about that again. Do you have any evidence that anyone explained to the electors prior to them signing this document what a duly elected elector means legally? You know, if they had any legal information explained to them by lawyers or anyone else prior to signing, if you know.
There was some discussion at this meeting. I don't know what that discussion was.
So you don't know, so you don't have specific information that they will explain, hey, to be duly elected, you have to actually be certified by the governor of a state as your party being the winning party. You don't know if they were explaining that, correct?
Correct.
So you don't have specific evidence showing that they were explained. It's another way of asking the same question. You don't have specific, is it correct that you don't have specific evidence showing that in this room or any of the other electors were told about the legal ramifications of saying that they were duly elected?
I don't know what was said in that meeting.
Right, and so you answered my question. I'll just leave it at that, instead of trying to get you to answer my question. So you don't have any evidence of it.
Asked and answered.
He hasn't answered it, but okay, I'm going.
Yes.
He answered it his way. All right, you testified, let's move to this topic. You testified that when you learned that this document, which is People's 11, was actually sent to the archives, you said in your testimony, it wasn't just signed by them, it was actually sent. It seemed in your testimony that that took on some significance to you, the fact that they actually mailed it. It wasn't just people sitting around writing a document, right? It was significant that they mailed it, correct, to you in your investigation.
Yes.
Okay. So then my question becomes, and did that make a difference to you in pursuing the investigation that they actually someone mailed what the electors signed to the archivist? Did that make any difference?
Everything made a difference in the totality of this investigation.
Okay. So then did it become incumbent upon you in your investigation to try to figure out who knew that these documents were going to be mailed, since that was now an important part of the investigation, the fact that they were mailed to the archivist? Did you try to find out who knew about that mailing that was going to happen?
Yes.
And did you find any evidence that Rose Rook knew, any specific evidence to her, that she had knowledge that what she signed was going to be mailed to the archivist in Washington, D.C. after she signed it?
I don't recall that.
So as you see there today, you can't point to anything specific.
Yes, I don't recall.
Okay. You say you don't recall, you kind of put me in a trick box. Now I have to say, I want an answer. Is there anything that would refresh your memory? That question?
Again, I don't know what was said in the meeting.
You already answered the question that you don't need to do. There's no specific evidence that Rose Rook knew that this document was going to be mailed to anyone, correct? You don't have any specific evidence that she knew.
Based on the totality of the investigation, it appears that the document was going to be mailed. The electors going up were told that they were going to go to the Capitol to try and serve the document.
Judge, I'm going to object to hearsay right blank. Rodriguez, hearsay of speculation.
Let me
The objection is sustained.
let me ask you another question. Is there any specific evidence that, because you didn't really answer my question, is there any, do you have any specific evidence specific to Rose Rook? And I'm not talking about walking to the Capitol. I'm talking about mailing. And that was my question. It wasn't about if she had advance notice that you won't be walking to the Capitol to try to deliver the alternate ballot. That's not my question. The question is, do you have any specific evidence that Rose Rook knew that this document was going to be mailed by the Republican Party, as opposed to going through this proper state channels? It was going to be mailed by the Republican Party to the archivist in Washington, D.C., in the United States.
No, but based on the totality of my investigation, it appeared that it was going to be mailed.
Cool. Like, what is, Sorry, good question.
I was just gonna follow up.
Oh, I know,
You
right.
can answer.
I'd rather you do it. Then you won't be.
I just want, well, I don't object.
judge too.
I don't object. I just want to know, he said based on the totality, it became apparent, so I don't need to explain what does that mean?
So it just means that the information that I received from Mr. Chesbro, the videos that we've watched that said, that where the defendant said that, we voted today, the votes are going to be sent off. So that is the information that with Marianne Sheridan, with Michonne Maddock, and the videos that we've watched that said that we voted today, everything's going to be certified. And we're sending our votes to President or Vice President.
Okay, because your answer was no, but based on it. So it's really yes, then based on you have evidence based on that.
The totality of the investigation would lead me to believe yes.
Okay, thank you.
Well, we just went over the fact that there's no evidence that Rose Rook knew or had any communications with Ms. Sheridan prior to signing the document.
No, what I recall is there was communication through Telegram. I don't know when that took place, if it was before December 14th or after December 14th.
But again, because you don't know doesn't make it evidence. I'm saying you don't know of any evidence that Rose Rook was even talking with Marianne Sheridan or knew her prior to December 14th, 2020, right? We went through this. I don't want to have to go through it again. You don't have any evidence showing that happened. Communication, right?
They were in communication, yes. I don't have specific evidence before December 14th or after December 14th. All I know is they were in communication through Telegram.
Yeah, at some point. And
Sorry, couldn't, through what?
Through Telegram.
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 It's a.
But, sir, you understand it's important to know the timing of these things, right? Timing is important. What she knew at the time she signed it is really important for the judge, in this case, to decide whether to bind the case up, right?
Yes, sir.
Okay, so it's very important that you're specific and you're accurate. And so I appreciate that you want to look at the materials, but I need to just answer the simple question. Now, I'll make it easier. Apart from the your ambiguous understanding of her proffer, do you have any extrinsic evidence, any external evidence, text messages, phone calls, anything showing that Marianne Sheridan and Rose Rook were communicating prior to December 14th, 2020?
Your Honor, I believe this question has been asked
This was
and
answered.
answered several times.
This was
And
answered.
so then it's no. It's no. So you agree that there's no evidence there, right?
It's been answered.
Right, sorry. It's a preparatory question.
It's still asked to answer.
Leeway, I guess, is not a thing. All right, so if they weren't in communication prior to December 14th, 2020, you seem to be implying that Rose Rook knew it was going to be mailed because of statements made by Michonne Maddock and Ms. Sheridan, but you already testified, asked an answer, if I asked it again. You've already testified that my client isn't talking to either of those people prior to December 14th, 2020.
Your Honor, that's a mischaracterization of the witness's answer.
He wouldn't answer.
I think he did testify that he didn't have any evidence of any prior communication with this client and Ms. Sheridan, but you just included Sean Maddock, and I don't remember us addressing that.
And the
I
witness
did,
said,
but
his evidence was that there was communication between
A telegram.
Ms. Rook and Mr. Sheridan through Telegram, but he could not say what the date range was. He never said if
Your
it
Honor,
was
I'm
before or
gonna-
after.
the Attorney General's office, they were not this attorney, but they were at the proper. They know that my client didn't know Mary Sheridan before. They know that, so this is a false representation. The
Well, we're
Attorney
talking about
General-
the testimony though.
No, I'm objecting to false representations being made. It's not true that she said that she knew her prior to December 14th. So why are you trying to imply that? I don't understand it,
I'm
Judge.
sorry, but there's no implication. I'm just going based on
We're
the
talking about
witness's
testimony.
testimony.
She's not offering testimony.
No.
So we're talking about what the testimony was.
Do you have any evidence, sir, as you sit here today, that you can think of that my client and besides this statement, you say might mean that they were talking before December 14th, without, you don't have any reason to think that, do you?
I don't know. I don't know if they were talking before or after December 14th. To answer this question a little bit further about text messages or the what was it, you said email?
Anything.
I don't have that.
So it would be consistent with your investigation, everything you found. That they didn't know each other before December 14th, correct?
Yeah,
I think he's saying he doesn't know.
Ah, Now, you've written, I think you testified over 100 reports in this case, so,
Yes,
and you've spoken to many witnesses, right?
yes,
And at one point you testified the case took up to 60 to 70% of the case load, correct?
yes.
Now, you know from your investigation that some, if not all, of the 16 electors, you know, and you're investigating criminal intent, right?
Yes,
Because that's really one of the critical elements in this case, is did these folks intend to fool anybody or cheat somebody by signing this document, correct?
Yeah.
Okay, so you investigated that. And so my question to you is, didn't your investigation reveal that some, if not all of the electors believe that what they're signing was a contingency document? And when I say that, I mean contingent upon some other event happening. Isn't that what you heard from all the electors that you interviewed?
but there was,
Your Honor, I wasn't gonna object until the last part of that question. Isn't that what you heard
Yeah,
from
no,
all? That's hearsay.
This is invested, it's not proper for the truth. I
So
was
it's
asking
being offered for,
to explain why to understand why he would go and try to get a warrant when he knows that these people, he has this information. So how did it affect his investigation? Why did he try to get a warrant? Does he have some other motive? It goes to his bias potentially, it goes to his motive for this case being here.
okay, the objections overruled.
Now, what was my question?
I was just asking to repeat it.
You interviewed a lot of people, and I said, and I think my question was, from all the people you interviewed from your investigation, you know, as you sit here now, that some, if not all, of the electors believe that what they were signing was only going to matter if some other event happened. And that's what I mean by contingency. Some other event happened, like a recall or a court case or something. You knew that that was their intent from your investigation because you talked to them and they told you that. They told you we didn't expect our vote to count unless something happened, didn't they?
Based on the totality of my
Yes.
investigation, I received that information along with other information that contradicted those statements.
What information did you find that contradicted the statements that electors thought their votes contingent?
Through statements or interviews. I don't recall specifically, again, as you mentioned, there's many reports, many documents, but again, I'm referring to the totality of the investigation, the statements or information that I learned through that investigation.
You know that I'm here representing this group, right?
Yes, sir.
You know that she's charged with serious felonies, correct?
Yes, sir.
And you know that I'm trying to understand the evidence against my client during this preliminary examination, correct?
Yes, sir.
And in order to understand the evidence against my client, I need to know what evidence you have that Rose Rook, in particular, did not believe that her signing was contingent on another event. Do you have any specific evidence as to Rose Rook that she did not believe that she was signing something that was contingent on the results being changed?
I believe it's the same question you're asking me. Again, based on the totality of my investigation, I received information or learned information that some said that, yes, it was an alternate plan. Others said that it wasn't.
My question is, how do you know? I don't mean to interrupt you, but I want to just keep you limited to my question, which is, what evidence do you have that she didn't think it was contingent?
I don't recall the information, as I just told you. I don't recall the specific parts, but again, this is based on the totality of my investigation.
But I mean, so are you saying that you can't recall the evidence as you sit here, that convinced you that Rose Rook wasn't just trying to do her duty?
So I'm able to recall the information, that specific statements I'm not able to recall.
What's the information about Rose Rook that shows she had specific intent to defraud or cheat people when she signed what many electors have said is a contingency? What's your evidence against her? Not Rashawn Maddock or anyone else.
I don't recall, I'm not following you with the question, maybe you could
Yeah, I'll
rephrase it, I don't understand.
Okay, what's like specific evidence someone's intent can be what they say. You agree with that, right?
Yes,
Did she ever say, do you have any evidence in your investigation that she made any statements that showed that this wasn't contingent, that she thought that they were going to try to replace the Democratic slate in some illegal way? Do you have any evidence of it?
Again, this is based on the totality of my investigation. I presented the information in the affidavit.
So is your answer that you can't think of anything specific to show that this lady in the front row here had a specific intention to cheat or defraud someone? I want to give you the time to do it. I'll give you as long as you need to answer it. Tell me what the evidence is. I want to know.
Well, I think the evidence has been laid out in the investigation. Again, there's thousands of pages of documents.
Well, you have to answer that last question. Do you have specific evidence that shows that Rose Rook has intent to defraud?
Yes.
Okay, what is the evidence?
Again, Your Honor, that would be statements that I've gathered through the investigation that contradicted what Mr. Velada said about she was just there to assign a signature page or sign a document, and that was that.
Okay, and your previous testimony, these are not statements that were hers, they were statements from others, correct?
Yes,
Okay,
that information.
next question.
And I guess I need to dig deeper into that answer, because it sounds like you're saying some people were saying that they knew it was going to be done. It wasn't contingent on anything. And that's great, but I'm asking you if there's anything that specific to Rose. So is your reasoning then, because other people were saying it, then she must have known? Is that what you're saying?
No, the information that I gathered led me to believe that they intended to send those votes to Mike Pence.
When you say they, I'm really trying to be specific here. I'm trying to keep it.
That would include your client.
I know you think it would, but I want to know what is the evidence of it? What is the evidence that my client intended this not to be contingency? It sounds like you said, well, some people said it was a contingency, some said they aren't. Now I'm saying, how do you know from your investigation what bucket my client falls into? Contingent or non-contingent? You said some thought it was contingent, some didn't. How do you lump her with the people that thought it wasn't contingent? What evidence do you have to put in there?
It appeared to me, based on the statements and the interviews that I've done, that all the people that had gathered that day in the Michigan GOP headquarters had known that.
Pardon me, I didn't hear that last part.
Had known that.
It became apparent to you. How did you come to that conclusion that Rose had to know that? Just was it because she was physically there? That's all.
Yeah.
Okay. So being present and having her signature, that's the evidence essentially against Rose particularly, correct?
Yes.
You don't have anything more. There's not text messages where she says, I want to commit fraud or anything to support the figure. It's just that she was there. So, and then she signed, correct?
Yeah.
And then the Facebook statement, right? Yeah, that too.
Yes, sir.
Those three things, right?
Yes, sir.
That's it. As far as specific intent.
Again, that would be no, because there's information from other witnesses who were there at the time.
You're going to get specific to Rose Rook about what she knew before she signed the document, that she knew it was going to not be contingent.
That she knew that it wasn't going to be contingent. Yeah. I don't recall again that information that I gathered.
Was there anything that you could
report.
look at to refresh your memory? See, if there's anything specific to Ms. Rook, and I said take all the time.
No, I don't.
You don't have anything like that.
No, I mean, other than the entire report, looking through the information and the timeline of the sequence of events.
I mean, there's nothing specific you can
No.
offer.
No,
As for
sir.
Rose Rook showing that she knew it was not a contingency. So she very well could have believed it was a contingency
Objection, Your Honor.
based on your investigation.
Cause for speculation.
Doesn't, his previous answer that he doesn't have any specific information, so your question is,
Yeah, if you have.
could she have
information,
believed that it was?
Put up when one of the people that believed it was contingent, correct?
But with all due respect, facts are not heard in the vacuum. This is a conspiracy case. So asking for isolating evidence to one defendant when it's a 15 defendant case is probably.
Well, he's defending his client. He can't defend
Oh,
everybody.
no, I
Right.
understand that, but what I'm saying is asking for evidence that is one defendant specific in a 15 defendant case is really hard because facts can't be heard in a vacuum. But my objection is to drawing that next question that causes for speculation, that's saying what Ms. Rook did or did not know.
Okay, but his question was whether or not Ms. Rook, or if it was possible that Ms. Rook could have believed that it was a contingent.
Right, and
And I think that that's a question he needs to answer, because if he believed that, then why would he have included her in
well,
his?
if
That's right.
the witness believed that, or if Ms. Rook believed that, because I don't think he can
Well-
testify to what she believed.
Well, first he's asking, was it possible? Because he doesn't even remember or has any specific evidence that he can identify that he had knowledge that she knew that this was gonna be sent. He's not providing that information.
Yes.
And so he's got to take it a next step further, because your witness doesn't know the information.
Well, I think maybe I just need clarification on the question. What I was objecting to was this witness testifying to what
Whether or
the
not-
beliefs of Ms. Rook, but if it's what the witness believed, then I believe that's a fair
But
question.
I think his question was, it possible that she could have believed that? We don't know what she believed. It's possible.
Well, that's speculation though.
Well, I can change it from
But,
possible.
well, it could be reasonable or unreasonable. I think it's a valid question, so I'm gonna allow it. Objections overruled.
Let me ask you this way, isn't it a reasonable possibility that Ms. Rook thought it was gonna be continued based on your investigation? Since you have no evidence really to prove the
There-
contrary.
No, there was no recount that was ordered. They were not meeting at the state capitol building. Mrs. Rook has experience in party politics. She understood, according to my report, and the interview of her, what her job as an elector was. And so to answer your question, no, but again, you're asking me to speculate on what she
No,
thought?
I'm not asking that, sir.
Okay,
I'm asking you a simple question, that based on your investigation, wouldn't you agree that it's a reasonable possibility that Ms. Rook thought she was doing her job, signed the document, didn't see the other page, and did not intend to defraud anyone?
Well, Your Honor, I'm going to object because one, some of that was asked and answered, but then there was some additional stuff that would cause for speculation.
Well, he said based on his investigation. Is that a reasonable conclusion based on his investigation? That doesn't cause for speculation. That tells us what it was essentially, if he answers one way, it would show that I did my investigation and I went one way, even though the reasonable conclusion was the other way. So I think it's a valid question. You need to answer it. Objections overruled.
Thank you.
no. So these.
So you don't, let me
these
just understand
folks-
your answer. You said no to the answer, the question of, you don't think it's reasonable that
He doesn't think that's a reasonable
that's a
conclusion
reasonable conclusion.
based on his investigation.
Okay, and
Yes.
what specifically can you point to that, if there is, maybe there isn't, maybe it's just a feeling you have, I don't know. There's something specific you can point to say, I know she didn't think it was contingent, besides the fact that she was there and other people were talking, saying it.
I think he
You're
just went
not
through
gonna-
that.
Yes, I was gonna say that was asked and
He
answered.
just went through all of that.
And you, so you, but you still think it's just not reasonable.
Asked
She
and
was-
answered.
He already answered that too.
Yeah,
So did you look at Facebook posts by the electors to try to figure out what their intent was.
Yes.
And you look at Mayshawn Maddox in her Facebook post, correct?
Yes.
And she posted, did she not, on December 14th of 2020 after signing the document at the headquarters?
Yes.
Do you have in front of you what's Exhibit D, Defense Exhibit D? And I've provided a copy to the court and to the government. I'm happy to share with my other counsel if you want to see it. See Exhibit D.
Yes.
And you've obtained by search warrant Mayshawn Maddox's Facebook account.
Yes.
And did you read her post to determine her intent? Did you look at her post?
Has this been admitted?
What is exhibit? Can I ask what is exhibit B? Just what?
Oh,
is it?
it's a post. You wanna see it? Yeah.
It's not been admitted though.
No, it hasn't been admitted. It was admitted, well, it was admitted.
It was not admitted in this case.
Not, hasn't been admitted. I'm gonna try to lay it.
Oh, okay, thank you.
And I may not admit it. I may not admit it. I'll just ask him. But did you review a post from Mayshawn Maddox on December 14th of 2020? That's shown in Exhibit D.
Yes.
Do you have any reason to believe that this document that I gave you, besides the highlight that was added, do you have any reason to believe that this isn't the material from the material that was produced in discovery? And as an officer of the court, I'll represent to the court that this is from discovery, but I'll ask you, does it appear to be consistent with the materials you received from Meta?
No.
No, so you don't recognize it?
No. I'm just, yes, it's within the material that
Okay,
was provided.
I'm using your own material.
Yes, yep. No, I was trying to answer your question, but perhaps I.
And so I would move to admit Exhibit D. Your Honor, it's not being offered for the truth of the matter asserted. It's being offered to be circumstantial evidence of intent, which is what this investigator looked at to determine whether he was going to seek a warrant in this case.
Okay, this was Facebook post
Yeah, Facebook post by Mayshawn Maddox on December 14th.
that he came about through what,
He got it from the search warrant.
from a search warrant?
This,
Yeah.
this did not come from the search warrant.
You just said yes.
I just said it.
Well, Your Honor, I have a duty to correct it. that
Okay,
This is not how Meta sends their returns.
okay.
Your Honor, I'm
We
gonna
have,
object as the prosecutor, you're gonna testify now?
This is an objection, so.
it's
I have
it's
a
an
duty to
objection that
correct.
this is not an accurate exhibit,
I
meta.
didn't make it. I got it from my discovery. I'll tell you that.
Was this the complete,
She's making factual representations.
This might have been a
as to what that
summary
is or
done by-
isn't. That puts her in a position of being.
as to how Meta provides a return? Is that
Yes, that puts her in a position of being a witness to testify and make factual.
No, she can
representations.
object that this is not this is not accurate because it's not how they send them, so.
Well, she's contradicting what the witness had said.
It's during an
It's
objection.
an objection, that's the whole point. She's
The
objecting.
evidence is the witness's answer to the question. not the
I
prosecutor.
recognize that, but she's objecting. And I'm not putting her on the stand because of that. That- I want to know if this is how he received the evidence.
I think that question is most appropriately addressed to the witness, not the prosecutor.
I'm asking the defense attorney who presented it, how he received it. He said this was what he received in discovery. This is the exhibit you received it
Yeah,
this
I
way?
just took this from my discovery.
This the whole packet or you just took a page of it?
I don't remember if there's more. There might be more. This is all I thought was relevant to my questioning.
Yeah, well, that was my concern because the objection is that this doesn't appear to be an accurate reflection of what was provided to you in discovery.
That's
And
not true.
the-
She even confirmed it.
That's not my objection, Your Honor.
She said it was.
Well, my objection was it's hearsay, but I have a duty to correct inaccuracies, and this document, defense proposed D, did not come from Meta. It was provided in discovery, but it did not come from Meta.
okay.
That's what I was correcting.
Got
Your
it.
Honor, my objection is that that representation is a factual statement regarding an exhibit. And that's putting the prosecutor now as a fact witness, which I assume nobody wants to do. But I think that's what's happened
The question was, well, this was presented that this came from Meta.
by the witness. The witness.
He
said
didn't
it.
say that, he stated, isn't that true? He said, yes, she objected.
My objection was already on the record.
To cor-
when you-
right.
And he asked a question during the objection.
Correct.
So
The
we're
question
not,
was posed, there was an answer given. That's the evidence in the case, not the prosecutor's explanation or commentary or anything along those lines. There's certainly redirect that can take place.
I agree that there could be
But
redirect to address that.
Unless we're gonna put the prosecutor on the witness stand to talk about factual statements, I think it's inappropriate.
Factual statements or how evidence was turned over.
and this was not a fact-finding session. This was during the people's objection, which the court had yet to rule on when counsel just asked another question.
Okay, the objection was whether or not this was hearsay. He said this was provided from Meta.
Right.
And that's when he said, yes, this was not an answer given to his question. This was something, him responding in the middle of an objection. The objection was whether or not this was hearsay. So she's not going on the witness stand for that. Back to whether or not you received this as part of your discovery.
Yes.
Okay, and your objection is hearsay. You're saying this is not being offered for the truth of matter asserted.
Yes.
What is it being offered for?
It's being offered to understand the investigation. Why did, because I asked him, we've already covered this topic. It goes to the same topic we're talking about, which is the intent of these
So-
electors. He's
So
looking
it
at-
goes to credibility.
Yeah, credibility. It also
And
goes
to corroborate the statement or discredit a statement, what is
Yes.
it being offered for?
It's being offered for, again, it's not, the reason that it's not hearsay. Okay, if you look at the words, it's not being offered to show, today the delegation voted.
Okay.
I'm not introducing it to prove that. I'm introducing it to prove that the intent of one of the electors here, by the words themselves, they're not hearsay because they're not an assertion of a fact. They're not, if it's not an assertion of a fact, it cannot be hearsay. Instead, it's a statement of that we believe we need more time in light of what's been revealed. And it says, today we did not replace any Democratic electors. That's also not for the truth.
Part of the concern that I'm having with this entire exhibit that you're now trying to admit is, I don't know that a foundation was properly laid.
Yeah.
on
That's
it in
that's
the
why I
first
thought the
place.
objection.
That was what I thought the objection was gonna be too,
I
because I didn't
see that
understand
yet.
I didn't understand how we were moving to admit. That's why I asked, was this admitted? Because you asked him questions about it.
Well-
And so, that's why I have no clue where it came from. You didn't ask him what it was. None of that ever happens.
I'll do that now.
Well, I was trying to deal with one objection at a time. Next
Well, we
time.
can't even get to it being hearsay because there's no foundation.
And can we just?
I don't
cut
know
off
what
the
it
hearsay
is.
Objections, Your Honor.
No.
When-
I'm sorry, what?
If we could just cut off the hearsay objections in general, when it.
No, we
comes
can't
to-
cut off the hearsay objections, just like I can't cut off your objections when she's trying to put evidence on the
I'm sorry,
record.
if you could let me
And she's
finish.
got to get them from 6 different people. And you all aren't giving her any allowances either.
I haven't objected much to any document that she's.
In regards to court statements, so you're aware of Zell's representation and every chance I get to.
As you should, but he's asking to cut off the,
No, no.
I'm responding to that, I'm
You
not
didn't
cutting
even-
off people's
Let me-
objections.
before I finish my sentence, so
Yeah.
that's not what I was asking.
The court made a statement about 16 attorneys. I'm one of them.
I said 6.
Well, I'm sorry. I've got a family. I'm back here. Regardless, the court referenced all the attorneys in the courtroom and while it may be, I don't know, it's not unfair. She decided to bring the charges. Yeah, she's got to deal with it.
I didn't
On the
talk about
court-
the
in the
fairness
court-
of, we didn't discuss any
No, no.
fairness. We didn't discuss any of those things. We're not even addressing any of, there's no reason for you to respond to my response, actually. So I'm talking to him requesting to cut off the hearsay objections. We're not gonna, I said, I'm not cutting off any hearsay objections. I've not cut them off for the defense counsel when they're giving them the other way. Move on.
Okay, I need to make a record because you had me making a ridiculous objection. I did not object, I did not ask to cut off all objections for hearsay.
You said, let's cut off the hearsay
You stopped me.
objections.
I didn't finish my sentence, Judge. I'm sorry. I know we're trying to get through this fast. I said that we have a specific area of the law, which is the law of intent. To prove intent, what people say in the ether, on Facebook, on the whatever, that's important because it's circumstantial evidence of what's in their brain, okay? Those statements aren't being ever used to prove the truth of what they're saying. They're being used to prove the fact that they were said.
We can't say they're not ever used to being,
Not in this case.
we don't know that. And so I can't cut off an objection.
All right.
Prematurely.
I'll withdraw that request, okay?
Yeah, I can't cut off an
Forget
objection
I said-
prematurely.
But just the concept of I'm introducing what someone said as circumstantial evidence of someone's intent and not for the truth. You agree, and we all agree it's not hearsay, so I just want to avoid these.
So if there's an objection, then that should be your response, and then we can move on.
Okay. Understood. Okay. Let me try to ask you.
Back to the foundation of this exhibit.
I'm not even gonna go there right now.
Okay.
Instead of that, I'm gonna say, did you review statements from Michelle Maddox? She made a post talking about not replacing the Democratic electors.
Your Honor, I believe we're still gonna need that foundation.
I'm asking you a question. I'm not noticing anything.
Well, you introduced the content of the state of the post in your question, and I think we still need to lay a foundation that it's not hearsay.
Right, but if I ask him, did he consider the statement? Doesn't matter. if it's
Right,
hearsay
but
or
you're
not.
admitting that you're entering facts about the statement, though, in your question, in the actual question.
Again, the statement itself is not hearsay. I'm asking if you reviewed this. That's all. It's not a hearsay statement. This is not hearsay that we did not replace any Democratic electors. That's
A
legal
post
question.
that Michelle Maddox said that they were not replacing their electors is
Yeah.
not hearsay?
No, because whether they.
Or
were
is it
they weren't,
hearsay
we
that
don't
you
know.
believe is admissible?
Pardon?
It's not hearsay, or are you saying it's hearsay that you believe is admissible?
I'm saying it's not hearsay because it's not being offered for the truth and it's not a statement of fact that I'm trying to prove. I'm not trying to prove that they did or didn't replace any Democratic electors. That's a decision for someone else. I'm just saying, did you hear this? Did you review this statement? Did you understand that she was saying that? And did that affect your view of the intent of these people? If they're all saying that it's contingent in their posts, I'll make it really easy. If everyone's saying this is contingent on this happening, they're all posting it.
I get
That's
it.
not hearsay. That shows that all these electors think this is a contingent event.
It is hearsay. The objection sustained.
Thank you.
Your Honor, I just want for the record to say, I don't think the Attorney General should be allowed to cherry pick. She just put in a bunch of exhibits with posts that were part of the discovery.
I
and
agree.
They put it all in.
I agree.
And that was allowed. If this is. not
But
gonna
I
be
asked him to lay a foundation for this. He told me he wasn't gonna do it.
All right, but if this isn't gonna be allowed, then I'm gonna make a motion to strike all those exhibits that have been in, because those are all full of hearsay then too.
Yeah, well, you had an opportunity
Well, I'm making.
to object. There was no objection. They were admitted without
Because I didn't
objection.
think there'd be objection to us using part of their discovery that they gave us, and they're not letting us use it. Then I'm gonna object. I just want it on the record. That's all.
You're not trying to admit this, number one. He was trying to question about something that has not even been admitted and present the statements that are on this document. I asked him to lay an appropriate foundation for it.
I'll try.
He told me he would not.
I don't think I need to, but I'll try.
I think you need to.
Your Honor,
Introduce an idea. Let's ask
before we
them.
get back to the proofs, can I respond? to
You may.
that? First and foremost, the statements that I admitted came in legally through the Michigan Rules of Evidence 801 G2. They are admissions by party opponent. And that is a long-standing rule of evidence. And last time I checked, that rule applies to all defendants, all parties. And when a defendant is introducing evidence, the hearsay rules still apply. Just because I have an exception that I can use does not mean that the hearsay rules do not apply to the defendants.
Agreed.
So admissions and party opponents that don't go the way the AG wants, will exclude those. I mean, these are statements by another defendant
Okay.
claiming that go to the state of mind and intent, and it's a statement by the defendant.
Co-defendants are not party opponents.
That's,
Thank you.
but I thought we got back to the idea that it's not hearsay. So I thought we got past hearsay objection. I thought it was a foundation deal.
I want you to address the foundation. This is something separate.
Oh,
This is nothing,
separate?
yeah, that's something
I won't
separate.
pay attention.
Thank you. Please don't.
Okay.
Move on.
So as far as, and I will say for the record, I've never had a prosecutor object for foundation for using the discovery they provided. And so I find it.
Well, I was the one who brought up the foundation. She didn't, she said hearsay.
No, she said
I
that was
asked-
part of her objection.
I asked, was this an exhibit that was admitted? Because this was passed to me. With a letter D on it.
Yeah.
And then you did make a motion to admit, and I
I
said,
did.
and that's when she said hearsay.
Okay.
I said there was a foundational issue.
I understand. Okay, foundation issue. Do you, was there a number of, was there a lot of discovery provided in this case?
Yes.
And were materials, including the statements of Michonne Maddock on Facebook, was that provided in discovery?
Yes.
Okay. Do you know if you reviewed as part of your, not necessarily this document, but this statement, do you know if you saw this statement contained at the top of Exhibit D? Have you ever seen that before?
Yes.
And you factored that in. I mean, that's something, one piece of evidence you considered in your investigation, right?
Yes.
And Your Honor, I intend to ask them about the statement. Do you have an objection about me asking about the statement?
I do not, but you're going to move to admit this, is that what you're saying?
I mean, I can try it.
Well,
It's not gonna be-
is this something that you want the court to consider?
I mean, now that the hearsay objection has been ruled on, I would hope that Ms. Logan would not object to the admission of that foundation.
Well, the court said it was hearsay.
Oh, you said this was hearsay?
I said it was hearsay. The statement, your question that you asked him a question, you had not admitted this. You didn't say ask what was on this. You asked him a question about what Michonne Maddock said. And I said that was hearsay.
Okay. Did Michonne Maddock post something for everyone to see on Facebook? Do you have any reason to doubt that this document you have in front of you, Exhibit D, is consistent with the Facebook materials you received from Meta?
No.
I would move to admit that's Exhibit D, Your Honor.
Any objections to defense D?
It's still hearsay.
He said it's not being offered for the truth of the matter, sir. Correct?
If it's
Yes.
being offered to show the intent of the declarant, then you have to take the statement as it's true. And also, what Michonne Maddock, I beg the question, what's the relevance as it relates to these things?
Yeah, I don't know how, other than what he stated in his response, which is that based on the totality of his discovery during his investigation, including statements made by Michonne Maddock, that was his response to this question about what specific evidence that he had that had anything to do with Ms. Rook's intent. He testified about Michonne Maddock's statements and other statements of other parts. To that extent, he's trying to, I'm assuming, flesh out what those statements were. I'm
trying to
assuming.
get out to why he thinks that Rose Rook, because he said it's based on the totality of what he looked at. I'm asking, did you look at these statements? Is that part of?
Well, I think you can ask that question without admitting the statement, because then the point is the content of the statement itself isn't what's admissible as substantive evidence.
I don't know that we can without admitting the statement, because we asked the witness, well, he asked the witness what evidence that was that he considered he couldn't remember.
But now that he has the statement in front of him and he's read it, you say,
Well,
was this?
he didn't ask for an opportunity to refresh his recollection. He's requesting now to admit it. And so
And
the objection is overruled. I don't believe it's inadmissible hearsay. I think it's going to show his motive or the motive. So you can go ahead and admit it.
Thank you.
I'm sorry, not state of mind,
Oh,
not motive.
Okay.
Can I
So,
see
now that-
exhibit D?
Yeah,
Do
you
you have a
should.
copy?
may I ask for a point of clarification?
Yes, I'll just let him finish.
Are you admitting this to show Ms. Maddox's intent?
I thought he was trying to
So,
show
I'm getting at.
the investigators' intent,
Yeah,
what I
I
thought he
just-
was saying.
Yes, the investigator, he
Okay.
previously testified, there's all this huge case. That's why I thought your client was guilty. And I'm trying to, find out where's the specific intent that she thought that this wasn't a contingent event. And he said it's based on all this stuff.
Yeah,
And
I
Michonne
think
Maddox-
my understanding, the reason why I admit it, because that's what matters, is because I believe he's trying to figure out Agent Shock's intent and why he moved forward with pursuing charges against Ms. Rowe, is
That's
what
right.
my understanding is.
Trying to find out what the evidence is against my client, essentially. Okay. So in exhibit D, can you look at the second to last sentence in the first full paragraph? Do you see where it says, today we did not replace any Democratic electors. We set Republican electors alongside the Democratic electors just to be safe, despite being blocked from entering the Capitol. The last time this was done was in 1961. Do you see that?
Yes.
Okay. And then there's more that she posts. And I'm referring to the highlighted portions that, for the record, that were not on the original materials that were provided to me. I'll say for the record, the yellow was added. But she says, it's our duty, it's here at the bottom, it's our duty to the people of Michigan and to the US Constitution to send another slate of electors if the election is in controversy or dispute. And it clearly is. See that?
Yes.
And that's something you would have seen before going to take the charges. If you know.
Not necessarily. The search warrants were done on Meta after.
Okay. Well, you haven't tried to get charges dismissed against this work.
I don't get charges.
But well, I mean, you already testified that you still believe that she had intent, right?
Yes.
So you still believe it despite looking at this. But let me ask you about this. Next page, exhibit B, the second page.
Yes.
In the paragraph that's highlighted, it says, it's posted, Democratic electors cast their ballots provided. Republican electors cast their ballots for President Trump. Both happened today. Both will be sent to DC. If corruption and fraud is proven in Michigan, if our state is flipped for the president, we have a certified ballot of electors for President Trump. Do you see that?
Yes.
So did that make you believe in your investigation that at least Ms. Sean Maddock, she thought this was contingent on what she says, our state is flipped. It has to be flipped, right? That's according to this, right?
Are you asking me to verify
No, I'm
what's
asking
on
you,
here?
did this get you to say to yourself, I'm asking what you're thinking, that
Okay.
you're investigating. And
Okay.
you see one of the electors saying, hey, if our state's flipped for president, we've done our job. We've got our certified ballot of electors ready to go. Isn't that essentially what she's saying?
And I took that into consideration with all the other.
Thank you. That's what I was asking.
Yes, okay.
So at least according to this, I know you have other evidence, but according to the intent apparently of Ms. Sean Maddock, you would agree that it appears that she believed, or at least the Post seems to say that it was contingent, correct?
That's what the post says.
Yes, thank you. And I'm gonna ask you about some more. I hope it goes smoother this time. I already gave the exhibit E to you. It's the same thing for the same reasons. Did you get materials back from a search warrant involving an elector named Amy Achinello?
Yes,
And you have exhibit E in front of you?
yes.
You said exhibit what?
E, Your Honor. Now this one I think might be easier. Do you see the certification on the front page of exhibit E?
Yes,
Does this appear to be a certified business record according to this first page that's certified by Benjamin Bomer, who's the custodian of records for Meta?
it's the cover letter that they provide. This is for a specific account identifier.
And then do you have any reason to believe that this document, have you had a chance, were you provided this document earlier so you could review it?
Yes,
And do you have any reason to believe that this document wasn't part of what you received from Meta?
just matching up the account identifier. Yes, that's what I received.
Thank you. Move to admit defendants exhibit E, Your Honor.
Any objection to defendant's exhibit E?
We're still missing the little foundation unless I didn't hear it. All I heard was that we just got meta records.
I asked him if this appears to be what he received from Meta certified. Is it what he received? Is there any question? I'll ask you. Can I ask a question?
You can
Is
ask
this
a
what you
question.
got from that? Is part of what you got from there?
Yes.
Okay,
So objecting?
Well, there are some highlighted portions I think you need to lay a foundation of those are admissible.
there's some highlighted portions of this exhibit.
Yes,
Sorry, it's for the same reasons, Your Honor. There's gonna be,
I'm trying not to object. I'm just saying,
I don't see what, I don't have it, so I don't know what you're talking about.
yes, you have it. Exhibit E.
It's not been provided me, which is appropriate until it's been admitted. So I don't have it. You might have given it to my judicial assistant, but I don't have
I understand. I got you. Okay. So what I want to ask you specifically about is page 2. Do you see similar statements? Well, let me ask you this. Do you see a post?
Connor, was it admitted? I'm
Uh,
not sure.
No, I thought he was explaining the highlighted portion.
There's
Oh,
apparently
okay,
going to be an
sorry.
objection to the admission based on hearsay potentially, so she wants me to identify what portions.
Okay.
That I want to.
So you're not seeking, I'm confused. What
I
is
am
the-
seeking to admit it, but there's an
Okay,
objection.
what is the highlighted portion? Did you highlight the
Yes.
exhibit? Okay, and your objection is as to the highlighted portions or?
well, all that's been established on this record is that it's a portion of a business record from Meta. That doesn't automatically make it admissible.
From Ms.
Why not?
Fascinello, correct?
It's a business record, certified business record. You provided me in discovery. How is that not admissible?
Well, just because I provide something to discovery doesn't make it automatically admissible. The
Right,
rules of
I thought
evidence
it-
still apply.
Right, I thought he questioned about whether or
Sure,
not
for foundation.
it was a return from a search warrant for Ms. Fascinello, is that correct?
Yes.
And that, it was certified,
Yes, it has a certified page. That's not, we just went through that.
and then,
Well, I'm just trying to avoid objecting for hearsay. If he lays a foundation for why the statements are admissible, other than that they're hearsay. That's all I'm trying to do.
It's the same purpose. I said that before I started my question. This is gonna be offered to show what one of the electors is saying their intent is, he considered in his investigation.
yeah, he's offering it to show Agent Shock's conduct, is
I'm
what
also
I'm
exploring
assuming.
what else you looked at, because he
Yeah.
said he looked at all this evidence.
Yeah, and he couldn't tell us specifically what the evidence was.
Well,
It said it was statements from other people and a totality of evidence. And we gave him an opportunity to review, he couldn't remember. And so he's trying to find out if these are the pieces of evidence, I suppose, that he reviewed. And if that affected how he got to the conclusion that he got to. Did I?
Yes, that's
Thank
absolutely
you.
right.
and Your Honor, understanding the court's ruling on defense exhibit D.
I haven't-
People.
Right, I
are
haven't
objecting.
ruled on E yet, because I'm trying to understand now the highlights. Is it similar to the other one? You highlighted specific
Yeah,
portions of this?
It's a post by an elector about what had occurred earlier. That
Oh,
would
okay.
There's
evidence intent.
Okay,
there's statements of a co-defendant.
correct.
And so I'm understanding the court's ruling. I'm going to object that it's hearsay.
I recognize that. Then I'm overruling the objection because he's not offering it for the truth of the matter asserted. He's offering it to show the conduct or how your investigator pursued charges against Ms. Rook.
Understood.
All right, so is exhibit A, E as in Edward received, Your Honor?
It's admitted.
Thank you. Okay, so turn to page 2. And Amy Facinello, she is an elector. Correct? She was an elector.
She, at that time, in 2020, yes.
And does she make a comment on a post? And I'm referring to the first paragraph that's highlighted under Amy Facinello. Do you see where she said, it says Amy Facinello commented on her post, and this is the comment. We voted and everything was notarized. However, the Capitol was closed per Whitmer and we weren't allowed in.
That says Whitler.
Sorry, hold on. She's gonna make me pull out my glasses. I wasn't planning on doing this, Your Honor. But no choice. All right. Amy Facinello commenting on her post. Quote, we voted and everything was notarized. However, the Capitol was closed per Whitler and we weren't allowed in. When the fraud is revealed, as it is coming out today, they can officially send our documents. Do you see that?
Yes, sir.
And you would agree then, the statement says when the fraud is revealed, they can officially send the documents, correct?
That's what it says. I'd like to clarify when you said she was an elector, she wasn't a legitimate elector. But
I
just to
understand.
clarify that, yes, to your point, yes, it says when the fraud is revealed.
And then if you look at the next page, Ms. Facinello on December 15th talks again about a contingent event, doesn't she? She states, if more fraud is revealed, so if more fraud is revealed, then the state legislatures could still present our votes to rescind the gaps. See that?
Yes,
So she's talking about state legislatures rescinding the Democratic certification, correct? Or rescind the vote for the Democrats, correct? Now, you would agree that that's a contingent event. It hadn't happened yet, the time they signed the document.
I don't understand what you're saying.
You would agree that the state legislature could not rescind, you agree that at this time, the state legislature has not rescinded the Democratic slate, right? They did not.
Yes, they did not.
Right?
No, they
But
did not
she's saying
decertify.
that if more fraud is revealed, then the state legislatures could still present our votes and rescind the Dems. So she's, again, talking about a contingency for their votes to be used, correct? If more fraud is revealed, and then the legislatures could act, right?
I don't know if it would be considered a contingency, but yes, that's what she said.
So I just wanted to get the, let me just ask. If someone signs a document, but it's only going to have any effect if another event happens, you would agree that that's a contingency, correct? And I'll give you a hypothetical, maybe this will be easy.
Yeah.
Right, let's say that you loan me $1,000 and I say, okay, here's a check. I'm paying you back. I give you a check for $1,000 to pay you back. And I say, wait till the 30th. Today's only the 1st. Wait till the 30th when I get paid on a direct deposit to cash it. And you say, no problem, Mike, no problem. And you forget, and you go cash my check. My check that says, this is a good check, I sign it, and everything. And it bounces. And then now you've got a fee. You come back to me and do you say, you defrauded me? Or you would agree with me, I didn't have any intent to defraud you. My money that I gave you was contingent on another event happening. That is my direct deposit. The deposit. Do you understand the hypothetical?
I understand the hypothetical. I'm not understanding how that relates.
I'm gonna ask you that.
So answer his question. He didn't ask you to understand how it relates.
I'm gonna
Okay,
ask you that.
okay, I'm sorry.
Okay, wouldn't you agree? And then you agree in
Yes.
my hypothetical.
Yes, I
I
understand
didn't
your-
intend to defraud you, right? I told you to wait. You forgot. There was no intent to defraud. You agree, right?
Yes,
Isn't that the same thing that these people were doing? They were signing a document. They were saying, here's our signature because we're supposed to do it by a certain date. And if you need it, a contingency event happens that the vote switch, then you use it. Just like my money is only going to be available once this contingent event happens and I get paid. Isn't it the same thing?
Okay,
I'm
there's a
going to
attorney standing.
I'm going to object. One, it causes speculation. Now, I understand that D&E show the intent and states of mind of those two defendants, but I don't think that that evidence can be attributed to the other defendants. It can be for the declarant and the declarant only, or the state of mind of the investigator.
Right, well, he's asking about, he asked him, did he understand what a contingency was? And he didn't seem to understand that. So that's how we ended up on the pathway of the hypothetical.
Yeah.
And so I thought the follow-up question was whether or not he understands what the contingency was. But
Do you understand?
then we
Yes,
jumped
yes, I
into a whole
understand
nother
what a
question.
contingency is.
And so now the question is whether or not does he agree that that's what
Similar.
defendants were doing.
these defendants were doing? And your objection is that,
I think that's speculation.
well, I don't think it's speculation because he's asking did he
No,
believe this was a contingency?
I'm going to withdraw my objection and let the witness answer. the
Thank you.
question.
But do you see what I'm saying? That at the time that I gave you my check in our hypothetical, I intended that they would only be used if it was appropriate. That is, I got paid. So at the time that these people wrote their signature, they only intended it to use it if a contingency happened. That's what these people are saying in these posts, right? Something else has to happen before their vote what they sign matters.
I'm sorry,
Now,
but
that's different from
I
the
was-
first question.
I was confused by that question. There was a lot of facts going on in there. If possible, could you?
You do
break it
do
up?
that
I'll
often.
rephrase it, I'll rephrase
You
it.
do put a lot of facts in your question.
Do you think that my hypothetical is a fair hypothetical for a voter if they thought that it was a contingent? Like, in other words, in our scenario, if these voters thought that, no, I see a lot of head shaking. Let me
Yeah.
rephrase the question.
You're gonna,
Do
cause
you
you're gonna
understand
lose
my
us.
hypothetical?
I understand your hypothetical.
How is that different from what you found? What about you?
I don't believe this document, exhibit number 11, was a contingency. The reason why I don't believe that is just, again, based on the totality of the investigation. These folks met, first of all, they didn't receive any notification from the state to come to Lansing. There was no certificate of ascertainment. There was no meeting at the state capitol building. There was a meeting in the basement of the Michigan GOP headquarters on that time. There was no official process.
I know that you're saying that you don't, okay. Do you agree that if an elector in this case signed only, but only wanted their signature used if the vote flipped to Trump? In your view, is that someone that you would seek a warrant for? Is that, that's a crime?
I don't understand.
Yeah, I didn't follow the question. I
All
didn't
right,
hear
so let's say that Rose went there that day. She only saw the first page. She signs her name.
Yeah, and I'm gonna object because we're talking about facts that are not in evidence.
Correct. I'm not following the question.
Let me, I'll rephrase it.
Thank you.
I think I need that point.
While you move on, I have a question that piggybacks on Agent Shock's last answer. Is it your position that, or is it your testimony that there had to be an official process for there to be a contingency document?
That was part of it, Your Honor.
Okay.
And again, I'm not asking you, was it legal what they did? I'm not asking you what I'm asking you is my intent. But you understand my question about. You agreed in general that you could, a document you write that's contingent on another event might look false. But that other event doesn't happen, but that doesn't mean that I have the intent to try. You see what I'm saying?
In a hypothetical situation.
But you found, you found from your investigation, other evidence that convinced you that Ms. Rook didn't think it was a contingency. And therefore, you think she had the intent to defraud, right?
Yeah.
Okay. But you can't really, we already went through it.
I didn't hear what you said. Your
I
voice
was gonna
dropped.
ask him what evidence, but
Oh, okay.
I'm not gonna do that, we did that. All right. But back to, in your defense, you do agree that she was also a contingent, based on what she said, it was contingent on other events, that her vote would count. You already talked about that?
I don't know.
Maybe I never asked you, let me ask you, looking at the second page of, that's exhibit E. Oh, let's look at the third page of E. She says, if more fraud is revealed, and this is on 15th of 2020, if more fraud is revealed, then the state legislatures could still present our votes. We're sitting it down. Do you see that?
Yes.
Okay. And you would agree that that would be a contingency that hasn't yet occurred because the Democratic slate was not rescinded at this point. So this would be a contingent event that hadn't occurred yet, right? And never occurred, right?
Yes.
Let's move on to another topic. I don't know if the court's planning on stopping.
Well, you're gonna stop because we haven't had lunch, but it's about when you think you can take a break. Okay, wonderful. I think your cohorts, thank you. We'll take a lunch. We'll just round it off to 1 o'clock. We'll see you at 2.
Thank you.
All right.
Okay, we're back on the record, and Agent Shock, you are still under oath. You can proceed.
Thank you. Investigator Chuck, before we went to lunch, I was asking you about some of the public postings of the electors that you looked at during your investigation. Do you recall that line of questioning?
Yeah.
I want to now ask you about Hank Choate. Hank Choate, one of the electors, the alternate electors in this case.
Yes.
And did he also post something similar, saying that what he signed was an alternate slate as a contingency plan? Did he say that in his post, if you recall?
I don't recall.
Anything that you have in court today that could help refresh your memory that you found that posting?
I have the search warrant, which are you referring to Twitter, Instagram,
I
or
think it was Twitter. I just don't
Facebook?
have it with me. So
Okay,
you recall it.
I don't recall.
Okay. Okay, so we talked about this before, break, but I want to direct your attention to May 22nd, 2023. Remember that day is the day that Ms. Rook and I met with you and some other people at the Attorney General's office?
Yes.
Okay, and one of the people that was present was the chief of the criminal division, or the Criminal Justice Bureau of the Attorney General's office, Danielle Hagman Clark.
Yes.
She was present, correct?
Yes.
And I believe was it Mr. Van Langeveld. How do you say his last name?
That you're very close. Van Langeveld.
Thank you. I don't know how to spell that name. So another at least two assistant attorney generals, correct?
Yes.
Were there any more? I personally, do you remember?
I don't remember.
No, not Dick, testified. So if you considered her proffer when you were deciding whether to go ahead and to seek charges against her, correct? Consider that.
I had reviewed it, considered it. I don't authorize the charge. But is that what you're asking?
Well, I mean, that was part of what you considered in your overall investigation. Remember you talked earlier about how in your overall investigation, you think that my client had certain knowledge, and I want to ask you, is that one of the things you considered in your overall knowledge of your investigation?
Yes.
And you know that from the interview that my client said that this was just in case. This is a just in case thing. You considered that, didn't you?
Your Honor, we're just backdooring in hearsay now.
Is it being offered for the truth of the matter asserted?
No, not for it. If he considered that as part of his, because he said that there's other evidence here that shows that she has knowledge. It's not from her statement.
Well, may I ask that the questions be rephrased and not elicit statements?
The question was, did he agree that his client said
it was a just in case thing?
was a just in case thing?
You remember her saying that?
Well, let me address the objection. You want him to rephrase the questions?
So if the question is, were there statements made by Rosebrook that were taken into consideration, the actual substance of the statements does not need to be put into the record.
I would disagree. The reason why I do is because he doesn't remember.
That's good.
Thank you. Thank you, Your Honor. So the fact that she said that this was just a contingency alternate slate is what she called it, right?
Yes.
It was a contingency. You knew that that was her position because you had the proffer, correct?
Yes, but the document.
No, sorry,
didn't
I'm
have
just
any
asking if you knew.
language
Sorry,
that-
does he ask you no question? Did you know that that was her position? That's my question.
I'm just trying to answer.
If you don't, you either know that or you don't. I think it's yes or no question.
Your Honor,
You know,
I would ask that the witness be allowed to answer the question and not be limited to yes or no if his answer is not yes or no.
Well, it's cross-examination. It's supposed to be yes or no questions.
If the answer can be answered yes or no.
This question, I think, could be answered in yes or no, though. Repeat your question.
It was such a great question. No, but I'm sure it was something like, you knew that it was my client's position that this was a contingency just in case, that she wasn't trying to override somebody else's votes. I mean, that's what she was presenting to you. I'm not saying that you believed it, I'm saying that that's what information you got.
Okay, okay, that's fair.
that
Yeah,
fair?
that's what it was presented to me.
Okay, thank you. That's all I wanted to say. And subsequent to Ms. Rose's proffer, did you find some other exculpatory evidence that proved that she was not being truthful? Is there some other evidence that you found? That
Well,
negated that? You understand the question? Like, did you find some other evidence that made you think that that was not true?
What is it? Sure.
That she thought it was just in the case? Or is your answer gonna be the whole case?
Yeah, it's gonna be the whole case.
Okay.
I mean,
I just didn't know if anything happened from the time of the proffer to the time you saw the indictment that was authorized by the Attorney General. Did anything happen significant with respect to the investigation specifically of my client?
it would have been, any additional evidence between that time frame that I gathered, plus the evidence that I gathered starting on December 28th.
I understand that, but my question is, do you recall anything specifically new that related directly to Ms. Rowe that you learned about, or do you not know?
I don't recall.
Okay. One of the charges in this case, in fact, it starts in Cat 1, is conspiracy. You know that that's one of the charges.
Yes,
And do you know what a conspiracy is?
where people organize and conspire to do something.
Illegal, right?
Yeah.
So isn't a conspiracy in your mind just an agreement between people who commit a crime, correct?
Yes.
All right. And what specific evidence do you have that, and you understand that the agreement doesn't have to be explicit, they don't have to write down an agreement, right? You
Yes,
understand that?
understood.
It could be an agreement that just happens organically, right?
Yes.
Okay. Do you have any specific evidence that Rose Rook entered into an agreement with these people that you said that you have no information that she even met prior to December 14th? Do you have any specific evidence that she entered into an agreement?
This document, the 2020 certificate of vote.
That's what I'm asking. So that's where you draw the conspiracy from, just the fact in your investigation.
Well, I wasn't.
Oh, I'm sorry. I didn't.
I wasn't on. And the fact that they met at a specific location. There was a discussion that was in the room. This was not at the state capitol building. This meeting took place. It was a celebration. It was documented through a picture. There was. Oh, okay, I thought you were interrupting.
No, I want to hear what LA is. I'm trying to find out what the.
Okay, so there was no recount that had been ordered. It was made known or publicized, I think even before December 14th by Shirky, that there was no evidence of fraud or it wasn't gonna, there was nothing that was gonna take place that was gonna change the outcome of the election.
Yeah,
And there's
let me
100
stop you there. Let
and-
me stop you with that. Well, keep going and I'll go back to you.
The 150,000 vote difference. So anyways, I lost my train of thought.
No, I'm sorry. I apologize.
That's
I didn't
okay.
mean
Yeah. I don't, when you interrupted, I lost my train
But
of
it
thought.
sounds like your answer, and correct me if I'm wrong, is it's really the whole case as a whole
Yes,
that led you to believe that. And you tried to be as specific as you could to tell me what the evidence was, right?
yes,
So you mentioned in your answer that State Senator Shirky making the public statement that there was not sufficient evidence of fraud to overturn the election. You mentioned that could be something that showed that they conspired, right? That they agreed to fraud, right?
well, I'm not sure what your question is.
I'm not trying to understand your answer. You answered that Mike Shirky telling people in his party that wasn't in a committee that he was on for Senate Oversight Committee. Isn't that the committee that investigated this?
Yes, I don't know if he was on the committee itself.
But that's what you're referring to in your answer, that Shirky made a public proclamation that there wasn't sufficient fraud to overturn the election, correct?
Yes,
Okay, you talked about this earlier, if these electors didn't have that information when they signed the document, because that happened later in the afternoon on December 14th, 2020, correct?
I recall that there was something earlier than that that was published by the party. Sure.
Wait, can you tell me what that is?
Uh,
Something was published by the party. If you need a minute, this is worth taking a minute to get, because I want to know if there's any, if there is something.
I want to say that there was some sort of press release or some sort of information, whether it was Twitter, Instagram, or something in social media that was before that, before the 14th.
Okay.
At 2
But
o'clock.
then, I guess going back to my,
I would have, again, I'd have to refer
you don't,
back to the
You're
investigation.
saying there was something earlier published, either press release or a post that indicated that there was no challenge to, or valid challenge, I just say, to the election results. Is that what you're talking about?
Yes.
Okay.
you don't know when that happened or who made that
I would
statement?
have to dig that back up.
How long will it take?
I don't know.
Do you think you could do it during the
Yeah.
course of this preliminary examination? I mean, not now, but
Yes, yeah.
So-
I would-
Your Honor, I request permission to recall investigator shop if you find that.
I've already granted you permission to recall.
I may have to recall you. Now I'll let you look for it. I don't wanna
Okay.
take any more breaks. Okay. My fellow pencils are to revolt. But even if there were such a press release prior to December 14th, 2020, you don't know, you can't say with any certainty that Ms. Rourke read or saw it, correct?
Yes.
Thank you. Now, we talked a little bit about conspiracy, let me talk about forgery. Forgery, okay, so I'm not gonna ask you, you're not an attorney, so I'm gonna ask you, you don't know whether or not forgery has been historically properly crime in the state of Michigan, you don't probably know these.
I'm not a lawyer,
Yeah,
so I don't feel comfortable making a legal.
Appreciate it, that's why I asked that, okay, won't ask about that. But you would say that your investigation, you would agree with me that your investigation didn't reveal that these electors, when they were voting, they were trying to get any kind of pecuniary gain. Do you know what I mean when I say pecuniary gain?
I do.
Monetary gain, they're trying to make money.
No, I don't.
And I'm trying to get at what your investigation. Well, okay, so if there's no pecuniary motive, you haven't. One of the things in forgery, another element of forgery, is that the defendant has to make a false document. Right? You know that, right? Make a false document. You agree that Rose didn't make the document.
Yes.
Sign the document on the signature page, but she didn't necessarily make the document. You agree with that, right?
Yes, so signing it,
Yeah.
adopting the document.
Well, but you, my question is about making the document, preparing it,
No.
drafting it. Okay.
No.
And you would agree that that was done by someone else, not Rose Rourke, correct?
Yes,
And your investigation revealed that there were two competing documents, right? One document was prepared by Laura Cox, which was clearly a contingent document, and the other was prepared by Kenneth Cheeseborough. Those are the two. Those were the creators of the two. Those are the two documents that were in play. Do you agree with that?
there was a document that was prepared by the Michigan GOP, and then there was the chess.
Okay, and you would agree that the Michigan GOP, Michigan Republican Party document was clearly contingent. You would agree with this, that it wasn't a document that was saying, we are the electors today. It was just saying that these electors are ready to vote for Trump if they're called to do so. You wanna see- yeah,
May I
absolutely.
review it?
Yeah, if you can take a look at it and
Yeah.
tell me if this is the document that
Thank
you
you.
got. Oh, I'm sorry. This is exhibit A. That's exhibit A. I provided a copy to the court. Happy to show. And prosecutor has a copy. Okay.
Okay,
Do you see that? And is that a document that you obtained during your investigation?
yes,
And do you know who you obtained it from?
was, I believe it was Troy Hudson,
Troy Hudson.
Troy Hudson,
And Troy Hudson,
or, what's the term?
Troy Hudson's attorney. Okay. And do you see a signature on that document?
Yes,
I know that you've had experts, handwriting experts, validate all the signatures in this case. That's right, correct?
yes. Well, no, it's not correct.
I'm sorry, I mean the signatures of the electors who are charged.
No, that's not
No.
correct.
Did you do that? Did you have Kathy Burden's signature looked at by
Yes,
the expert? Okay.
yes,
And does the signature, I know you're not an expert, but does the signature in front of you, is that consistent with the other signatures in this case that you see?
it appears similar.
I'm gonna ask the indulgence of the prosecutor Your Honor, to stipulate to the foundation of this document, since I proceeded in discovery of this. That he got it from an attorney for one of the people.
May I have one moment?
Absolutely.
Your Honor, for the record, I'm gonna make a point of clarification, and I really appreciate this, Logan. The document in front of the witness is the document, it's not exactly the same as the document he got from Troy Hudson's counsel, because this is a signed version of the document that I received from co-counsel. And there's no objection to the foundation, so
There's no objection. Your
I
Honor.
would just like to move for resolution.
Move for motion for defense A.
Yes.
Okay, and there's no objection.
There's no objection, Your Honor.
Defense A is amended.
Thank you. All right, looking at defense A, and Judge, you have a copy of that.
Thank you.
I'm sorry that it's printed really small. So I received it, but, you see the title. At the very top, it states State of Michigan Declaration to the Senate and House of Representatives. See that?
Yes,
And below it, it says recognition of presidential electors designated for Donald J. Trump and Michael R. Pence, correct?
yes,
Then it states, whereas 16 presidential electors for Donald J. Trump and Michael R. Pence were properly designated by the Michigan Republican Party, there was a meeting on December 14, 2020, by those electors to recognize and affirm their support for Donald J. Trump and Michael R. Pence. See that?
yes,
And it states, all have affirmed they are available to meet and perform their duties as a presidential elector by the United States Constitution, Michigan State Constitution, and Michigan Election Code 168.47. And that states that, right? Am I reading it right?
yes, you are.
And then finally, it states, all have affirmed that as required by Michigan's faithful elections provision of MCL 168.47, they would cast their votes for Donald J. Trump as president of the United States and Michael R. Pence as vice president of the United States. But these presidential electors are honored and affirmed by TSC. See that?
Yes,
So you would agree, at least, that this document itself, this is a document that affirms that the electors are ready to be electors, correct?
yes,
And but it recognizes that they're not yet, but they could be if they're called to action, right?
yes,
And you would agree that never was a legal event that occurred that called them into action, that made them duly elected, right?
yes.
But what happened in this case, from your investigation, you know that is that Sean Flynn is an attorney for the Trump campaign, correct?
Yes,
And what happened is isn't it true? What happened is that Sean Flynn snuck in a second document for the electors to sign that. Which is People's Exhibit 11. Yeah, the investigations show that the Michigan Republican Party was fooled. Let me ask you that. Fooled by there being a second document for the electors to sign?
I don't think they were fooled.
Well,
By it.
weren't they
I don't-
surprised by it?
Some of the Michigan GOP staff, well, one of them in particular was surprised by the document.
Okay. Let me back up. Wasn't Troy Hudson so upset when he learned about the second document? He got on the phone and he called the attorney of the Michigan Republican Party, Stu Sandler, and said, Stu, they're signing some other document. Do you remember that?
That's the one I'm referring to.
Okay. All right. So there are two documents in play, and you would agree that Laura Cox is the chairperson of the Republican Party. There's no evidence that she knew about it. You know that from her statement, she didn't know about it. She didn't know about this Sean Flynn document, correct?
That's from her statement, correct.
Do you have any evidence that Rose Rook knew of these two competing? She knew that there was one document that was supported by the Michigan Republican Party and then another document that Trump's attorney wanted to sign. Do you know from your investigation if she knew about this, that there was some tension between the Michigan Republican Party and the Trump campaign on what document to have it signed?
Yeah, that's a compound question.
Let me rephrase.
Okay.
Was
Thank
there
you.
some, your investigation didn't reveal there was some tension between what the Trump campaign wanted these nice people to sign versus what they actually signed? Like they wanted.
Wait, you confused me again, because you're referring to the same party.
So Laura Cox, you know, from your investigation, she negotiated with the Republican Party about the document, correct?
The Michigan Republican
Yeah.
Party? Yes.
Negotiated with the attorneys for the Trump campaign. They were talking about which document. These guys were talking.
I'm lost again. I apologize.
We already talked about there's two documents.
Yeah,
Wasn't there a disagreement at some point between the Trump campaign and the Michigan Republicans on what document was appropriate? There's disagreement amongst the lawyers. If you don't know. just
I
say
don't,
you know.
I'm thinking, just give me an opportunity to respond.
I will.
I don't recall.
I want to ask you about a statement you made under oath in the previous. You recall stating that you had no evidence that Kathy Burden intended to lead anyone to believe that alternate slate negated the Democratic slate. Do you remember testifying to that?
I do not.
I don't have a copy of the transcript. But if I asked you that question, what evidence did you have that Kathy Burden intended to lead anyone to believe that the alternate slate vote negated the Democratic slate? What would your answer be if I asked you that?
I can recall that through an interview that someone had mentioned that she led the meeting. She opened up the meeting and led the meeting.
So I guess that doesn't answer my question. My question is, did you have any evidence that Kathy Burden? Now, I'm only asking these questions because this is what testified to before.
Yeah,
But I believe
I
it's
understand.
So, do you have evidence that Kathy Burden intended to lead people to believe that the alternate slate negated the Democratic slate?
Could you just clarify negated? What?
Well, that was the exact question you were asked it. You answered
Okay.
it. So I guess
So I have the document. The document itself, where she's the chairperson. I have witness testimony that says that she opened and led the meeting.
but so beyond that, you don't have anything more.
That's what I was referring to. But beyond that, no.
Yeah.
I mean, not
The
that I
overall
can, not
case.
that I can recall it at this point.
All right. All right, now I want to move on to your affidavit. Before you resumed here, I showed you what I'm going to talk to you about. And didn't I show you a copy of what's been marked just for identification as Defense Exhibit H? I'm not going to release it. I want to ask you about you did an affidavit. You wrote an affidavit in support of the charges in this case, roughly on, not roughly, on July 18th, 2023, correct?
Yeah.
And I have it if you ever need to refresh it.
Okay.
And I want to ask you about, let me ask you this first. How many, you've made affidavits before? On cases, obviously, right?
Yeah.
And you take them seriously. Right?
Yeah.
And you're under oath. You're placed under oath by a judge. Right? You call in, you usually call a judge or you go see a judge.
I did not see her. I think it was sent electronically.
Okay, but in any event, you were making these statements under oath and you knew that the judge was reading it and relying on it, correct?
Yeah.
So the last thing you want to try to do is mislead the judge. Correct?
Yes,
And at least you wouldn't do that intentionally, correct?
that's correct.
Okay. Let me ask you this question. Did you write, and I'll show you. Okay. Paragraph 17 of your affidavit, July 18th of 2023. And I just wanted you to see it before I ask you about it. Now, after you've read it, then I'll take it back.
Yes.
Okay, thank you. So, statement I want to ask you about is in paragraph 27, your affidavit. You state,
17 or 27, I'm sorry.
sorry, paragraph 27.
You said
You have
so.
I'm sorry, my bad. 27. A lot of numbers. Paragraph 27 of Exhibit H. This is what I want to say. The candidates for elector and the MIGOP leadership knew prior to their meeting on December 14th, 2020, that there was no legal reason to create an alternate slate of electors. Did you write that?
Yeah.
Now, what I want to focus is on the candidates. Say the candidates knew before their meeting on the 14th that there was no legal reason to create an alternate slate of electors, correct?
Yeah.
And so it's one thing, you would agree, it's one thing to say there was no legal basis for them to sign this and think they were electors, right? That's one thing. But you would agree it's entirely different to say they knew that there was no legal reason for them to do what they did. You're saying that they knew that there's no legal reason to do that, correct?
That was my belief, yes.
Okay. But you also know, as you sit here now, certainly you know, that these folks were getting advice by attorneys, by people in the Michigan Republican Party, correct?
Okay.
They were receiving advice about whether they should sign this document. They were being told what to do by other people. You know that, right?
I don't have any statements that suggest that they were being told exactly what to do. There was interviews that were conducted. Nobody could come out and tell me specifically, person A told me to sign this document for B reason. Yeah, I don't have that.
Let me try to do this. Ask this a different way. You know, you just testified to it, that there was someone leading the meeting and talking to the electors, correct?
Yeah.
And you said that
It
was Kathy Burden.
Burden. That, yeah,
And you said that was Kathy Burden, correct?
yes,
Now, Kathy Burden saying something to people about what they're doing and why they're signing something, correct? You assume.
she was saying something.
Right.
Yes.
And you don't know what that something was, correct?
Yes, I don't know.
Okay.
I just
So
said
you
that.
don't know if she was telling the electors that there is a legal reason we have to preserve our votes. You got to sign this document. You don't know if that was said or not, correct?
That's correct.
But so how can you say, if you don't know what they were advised by, and you know that Sean Flynn was a part of this whole meeting in the basement on December 14th, 2020, you know that, right?
Yes, but I don't know, specifically
this is
what
one
he was
question.
doing or saying.
I'm gonna ask you just to answer me.
Okay.
The question is about Sean Flynn. You know Sean Flynn was there,
Yes,
correct? And you knew that Sean Flynn, you know that Sean Flynn eventually took whatever they signed and did something with it, took it away, right?
yes,
We know that. So you don't know what Sean Flynn said to these folks about why they might have to sign the document. You don't know what he said, correct?
correct.
So you can't say, can you, that electors knew that there wasn't a legal reason if you don't know what they were told.
I feel that I can, based on the totality of the investigation and the information that I obtained during that investigation.
So
That's why I wrote it.
So to take that further then, so if Rose Brooke had been told, or any of the electors, that they gotta preserve their rights, they gotta sign something on this particular date, or else they're gonna lose their votes. If they were told that, you would agree that that would be a legal reason that they didn't know there was no legal reason if they were told that.
Your Honor, I'm going to object. One, it assumes facts not in evidence and also cause for speculation.
Yeah, I don't know that he was saying that that's what they were told, because we don't know what they were told. I'm sure he doesn't know, but it does cause speculation, so the objection is sustained.
Okay, what I'm getting at, Your Honor, and Sean, what I'm getting at is, how can you say that the electors believe that there was no legal reason to do it if you don't know what they thought or what they were told? They could have been told that there was a legal reason. You agree with that, right? They could have been told that.
They could have been told any number of things.
So how can you say that they knew that whatever the attorneys were saying were what was wrong?
As I mentioned, through the totality of my investigation, I did not find anything that would support that, or that did support my statement.
You say you didn't find anything that did support your
No,
statement?
I didn't find anything. I didn't find anything, therefore, that supported my
Oh.
statement.
All right. We talked about how the electors didn't have any financial gain by signing this document. You still agree with that, right?
Yes, sir.
And you agree that at least some of the electors have said, and you read the post, they thought they were doing the right thing here. The electors have said that, right?
The electors have said that was part of it.
And not only the electors, but the Attorney General of the state of Michigan said that these electors believe that they were doing the right thing. Did you say that publicly?
Hearsay.
Objection sustained.
Thank you.
Well, did you consider what Attorney General Nessel said on September 18, 2023, and about this case during the course of your investigation? Do you know what she, first of all, do you know what she said? Publicly, that, and I'll wait for your objection. I'm gonna
Ask
go
the
ahead
way
and
until
object.
you finish the
Yeah,
question.
there was no question yet.
So I seek a motion. Okay, so what I want to get at is the Attorney General is saying that these people still think they're right. That's her quote, still think they were right. She said that.
Objection,
How does that,
hearsay.
how is that consistent?
Objection sustained.
Hingham County, that's a county that we're in right now, correct?
You're
Damn.
Not she can sit down, just ask the question.
I know something. My question is, that the case was first considered before the Attorney General, well, no. The case at some point was considered and rejected by the Hingham County Prosecutor's Office. Is that correct?
Objection, relevance.
What's the relevance?
I'm asking if that affected his, did he rethink his case? They said there's no case, did that affect you are going, because that happened before he went and got the warrant.
Well, that happened,
Well, let me rephrase it.
yeah, I was gonna say,
Let me
did
try
it
this.
happen long before? Didn't it happen before he even investigated it?
Yes.
Well, all right, then I'll ask you that way, that's fine. Did the fact that the Hingham County Prosecutor's Office.
Well, the
declined
question
case-
is, how is it relevant?
I'm asking how it, if it impacted me. Maybe he'll say, I don't care what they think.
I'll allow him to answer.
Did the fact that the Hingham County Prosecutor's Office wrote a memo on this and denied, like looked at everything and denied this case, did that factor into your decision to go ahead? Like, did that cause you any concern?
No, because I hadn't seen any sort of investigation that went with that memo. So I've only seen a portion of maybe the investigation.
And do you know whether or not the US Attorney's Office in Grand Rapids, that is the Western District, even if you don't know, do you know whether or not they considered this case?
I do not know.
You know that they never brought a case.
To my knowledge.
Objection, relevance.
Well, what's the relevance?
But it's the same relevance as before.
Well, this is different.
Fine,
You think
fine.
brought a case?
Then with that, Your Honor. I know. Thank you very much. Appreciate it.
And with the court's indulgence, I'd like to step around this side, so I.
Actually, so,
Fiction be over there.
Mr. Salata.
Oh,
Yeah.
Just as long as you stay near the mic, we're good.
How are we doing here? Is that working?
Yeah.
All right. I'm former military and I'm going to address you mostly as sir, and I've addressed the judges ma'am often, but usually they prefer to refer to them as your honor. But nonetheless, I'm going to refer to you as sir. Never been that good with names. You were asked about your prior history or work experience, is that correct? And you gave us, where all you worked and some different things. Did you ever have to take an oath or an oath of office to become a law enforcement agent?
Yes, and thank you for your service.
No, thank you. And during that, oath, were you sworn to support and defend the Constitution of the United States?
Yes,
And part of that is defending the rights of the citizens, correct?
yeah.
So during the course of your investigation, which you said is thousands and thousands of pages, did you find anything that would be considered exculpatory for especially Mr. Thompson?
Could you clarify that?
You understand what exculpatory is?
I'm asking you to clarify.
Do you understand what exculpatory
No.
is?
So,
It means prove they're innocent.
okay.
All right. So did you find anything in your investigation that would prove or tend to prove that Mr. Thompson was innocent?
Your Honor, I'm going to object this cause for this witness to draw a legal conclusion. This is a fact witness, not first of all, not a lawyer, and any determination of whether evidence is exculpatory or inculpatory along with you as the trier of fact here.
Tend-
That's fine.
The issue is tend to prove, I'm not asking for a conclusion. He's already made legal conclusions to this by making affidavits suggesting that these people have already done illegal things in his affidavit for the warrant for arrest. I want to know how complete his investigation was. Did he find anything that could prove to show they were innocent? Which goes along with the drunk driver. Did you find out if he was driving or not? If you knew he wasn't driving, that would be exculpatory. That doesn't call for a legal conclusion.
I would agree that if the answer based on his question, it really goes to his credibility, and he authored and swore to an affidavit indicating that there was evidence, at least to a probable cause standard of these crimes, so he can answer the question. The objection is overruled. Thank you.
Did you want me to repeat?
No,
Okay.
no, to answer your question, no, everything I found supported the affidavit that I swore to.
So you didn't find anything other than what would move towards a conviction, correct?
Yes,
All right, and the judge, when she swore you in, said something to the effect of the truth, the whole truth, and nothing but the truth, and then under penalties of perjury, correct?
yes, sir.
I want to go back to when you were hired then. Who was the individual that hired you for this position?
Objection, relevance.
What's the relevance?
I want to know who hired him, and because of the process of him being I'm gonna have to ask who his supervisor was. I'm gonna then go through and ask him what his marching orders were. I want to know if he was instructed to investigate for a crime or investigate to prove a crime. Two different things. So first off, this is foundational. Who hired him and who did he work for?
Your Honor, the purpose that we're here for is to determine if the 6 defendants before this court, if a crime was committed and if they committed the crime, who hired Special Agent Shock has no relevance whatsoever
I,
to that.
Brass, I go to the brass.
I would, well, I was gonna say preliminarily, I would think that it's not relevant, but if your ultimate goal, which is to see what his marching orders was, I think that does go to credibility. I would allow these line of questions in the inverse, meaning you start with what his marching orders was, and then
I was just looking.
but I won't allow it the other way.
I wasn't looking, I really didn't care who I was looking at the foundation side of.
Right, so
when you came on to investigate this situation, what were your marching orders?
To review the case and determine if a crime is taking place.
So you had to make a legal conclusion?
I didn't make a legal conclusion. I had to review the facts or information, investigate it, present it to a prosecutor who would make that decision.
But you made an affidavit also, correct?
Yes.
And
but
you
I
just
didn't-
said, I'm sorry, you made an
Sorry.
affidavit? Yes,
Yes,
and then you said to see if a crime had been committed, correct?
no,
Yeah, I believe that's part of what you said, that you were hired to investigate to see if a crime had been committed.
to determine if a crime has taken place is what I said.
Is that a distinction without a difference?
Move to strike.
was that a question?
Yes.
I guess you gotta
Sorry,
answer it
Hannah.
then. Is that a distinguishment, or
What's the difference?
what's the difference between what he said you said it and what you said?
I don't understand what he says. I'm.
He said that you said it, that your marching orders was to review the case to determine if a crime was committed, which is what my recollection of what you
Yes.
said was.
Yes.
But you just said something slightly different, so we want to know
Oh,
what the difference
it's
is.
the same then. I'm
Alright.
sorry, I thought I said it's to determine if a crime had taken place.
All right,
If you
so-
did, we just want to know what's the difference, if that was what you said.
I guess it's the same.
all right, thank you. And when you investigated this case, you did so with due diligence and all within the law?
Yes, I tried to do my best, sir.
Well, I don't want a qualified answer.
Yes,
All right, and you've always done that in the course of law enforcement service?
yes, sir.
Always?
Yes,
Weren't you sued in your personal and professional capacity for overreaching conduct and sued in federal court and state court and found to have committed tortious actions during the course of your professional conduct?
I have been sued, yes.
And you were found in court to have been, that you committed tortious conduct, but you were protected under governmental immunity, correct?
So
Yes or no? Yes or no?
I can't, I don't know.
Were you the defendant in the civil case being sued by
That's the thing. I don't know what case you're referring to, so.
my notes page on that one. It was in Beverly Hills, for conduct in Beverly Hills, when you entered a house occupied by certain girls.
Can we get a date?
Yeah, I'm getting back to it. What was the case? Let me see the date, Jen. Kendall, does that refresh your memory?
Yes, sir, to provide
January.
medical,
January of '09?
I don't recall the date, but yes, to provide medical attention to a woman inside the home.
You were called to provide medical attention?
No, we were called to the home
For what reason?
to investigate, I think it was a burglary.
Wasn't it in fact to investigate somebody sitting out front of the house, of a specific house?
That's what we found when we got there, but it was to investigate a burglary. Somebody had come out of the door that was missing, I believe it was missing some glass or whatever.
And you found out that the house was being occupied by, I think, the goddaughter of the parents?
Your Honor, we're getting too far into this case and away from its relevance.
I'm going into his veracity on this. He said that he investigated this case as professionally as he would any other case, and that his conduct has always been consistent with law enforcement. He's now, I've given him confrontation of a case there he's sued and found in of tortious conduct. And now he's trying to dance around it. She wanted specific date. He's asking specifics. I'm trying to give him the answers.
Okay, I think does he have clarity now or does he need further clarity?
Well, with
I don't know.
all due respect, he acknowledged being sued. And he's talked about to a certain extent, the facts of the case. But at this point, he's acknowledged the lawsuit and it gets past the point of relevance after that, if it's going towards credibility. The actual underlying facts.
The underlying facts are not really germane to the credibility issue. You're trying to,
That's fine. He asked me a couple other collateral questions and I was just,
okay, I think
Going
he's
back
brought up
to
to speed
clarify.
now, so I think, I don't need to go into any further detail, so you can get back to your, I guess,
all right. So you
credibility question.
So you investigated this case as professionally as you did in the case that you were sued on, correct?
Yes.
Gotta go in kind of reverse order of prior counsel. What's gonna happen on this with your predictor is every attorney is gonna be writing notes of the questions I asked, questions prosecutor asks,
I'm
and
gonna
he's
object to
asked.
this preview and just ask the council, ask his questions.
Proceed with the question.
You had indicated that nobody had marching orders prior to the meeting in the basement, where they signed, where the electors signed. The delegates signed their certificate, correct?
Nobody had marching orders.
You said prior to the meeting, nobody had given any direction to anybody for what they had to do.
I don't recall.
All right. And then one of the questions towards the end was, you didn't have any information that person A told any person to sign Form B for any reason, correct?
Could you repeat that again, sir?
I don't have information, person A told any person to sign the form for reason B.
Oh, yes, I do.
All right. So for there to be conspiracy, everybody has to be on the same page to say, we're signing this so that we can defraud somebody. And then you came to this one and you said, well, nobody had a meeting of the mind, so to speak, or I don't know of anybody had meetings of the mind. So let me ask you this. Was there, in your opinion, a leader to this group?
There was.
Yes
There
or no?
was.
Yes or no?
No.
All right. So we don't have a leader. Do you have any information showing that anybody had indicated to anybody else in this group, we're going to commit fraud?
There are several leaders of the group there. I don't have that indication.
So there are
There were
There are
several,
several leaders?
there's not one per se, there was a few. There was the chairperson, the secretary, and then there were some other people, according to witnesses, that were involved.
Okay, and you're alleging all of these were kind of like the bosses of this group?
The leaders, so when you said
Okay.
leader, I just wanted to clarify that.
When I say leader, I'm talking specifically about any illegal conduct. Was there anyone that was specific that you're aware of that forwarded the illegal conduct?
forwarded.
There's, well, they're being
I don't
charged with
understand.
conspiracy, fraud,
Yes.
different things.
So they were all gathered together on December 14th, had signed this document. The document was sent off to the National Archives and to the Senate. You know, there was no recount at that time. The party, Senator Shirkey, like we talked about, said that there's no reason to believe that it's going to change. And I'm paraphrasing here, that's going to change this vote. I guess what I'm trying to say is there was nothing that was going to change the vote. There was 150,000 vote difference. There's no recount. The Democratic electors had been summoned to the state capitol, had convened, you know, there was a certificate of ascertainment. I know I'm probably getting more into this, but I'm trying to answer your question.
All right.
Because I was confused.
Part of what you just said there was there were no successful challenges or anything to that effect. And the prosecutor had asked the question, very good, that there were no recounts requested. You said no. You said there were no successful legal challenges. Were you aware of any pending legal challenges?
Was.
So there could have been reason for an alternate slate to go in.
I didn't see a reason based on my the totality of my investigation for an alternate slate to go in.
All right, I've heard the totality and the judges accepted it, but when we get into the trial, if this goes to trial, I'm gonna demand that you give me very specifics, which I'm gonna do now. What did Mr. Thompson know and when did he know it?
I didn't. I have Mr. Thompson's social media post. Mr. Thompson declined an interview. What did he know? I mean, I could refer back to his social media post for what he knew.
So out of that, you'll be able to tell me what he knew from his social media posts?
Yes.
And now you're gonna go through all thousands of pages to ascertain that?
You're asking me here to do it.
I would
Are you saying
be.
you don't know it off the top of your head?
Off
You'd
the
have
top,
to-
yes.
You'd have to refresh your recollection?
Yes.
And he just said he'd have to go through all thousands of pages to do it from his social media posts, so.
Meaning you don't have any notes that indicate or would refresh your recollection to respond, you would have to go and review all of the return?
I don't think I'd have to review all of the returns,
Okay.
Your Honor.
I think that's what he's thinking, you're saying.
No.
Well, he said the totality of it, and I'm assuming that he's got volumes that he's gonna have to look at.
Well, I'm sure he looked at it, right, Agent Shaw?
Yes, Your Honor.
And made notes from it, correct?
Yes.
And notes specific as to each individual charge, correct?
Yes.
So I don't see why he would have to go through the entire.
As long as he can give me the
Return.
answer of what he knew and when he knew it, that's fine. If he needs to refresh his memory for that, that's fine.
Would looking at your notes refresh your recollection?
Yes, Your Honor.
Okay, it's club time for an after lunch bathroom break anyways. 7 minutes.
You can do that tonight.
You want me to hang on till now or? do you
Just
want-
leave them right ready. I will, because if you give them.
I'll have it done right
We'll be
now.
going, where the hell they go? I'll be over here chewing on something going, where what?
Fair.
Is that plugged in now? You have to pull the cord and turn it on. It's at 0. There we go. Aim it at me, if nothing else.
Yeah, that's good.
Okay.
Okay. That's better.
Aiming
Yes,
it
the
at
Frank's
you,
over
or do
there.
nothing but circulate
I'm just
hot
gonna stand up. I'm doing it right now. Sorry, everybody, I'm just standing here.
You think that's offensive to an attorney? We get paid by the word sometimes, so we just drag it up.
I know you got.
We drag things out.
It's
so-
sending her up and down.
I
Have it and,
What file?
anyways, they found it now.
Oh, okay, I don't know what. Oh, that's what Brendan's emailing me about now, and I don't understand what he wants.
You said Brendan or?
No,
Oh, I've had them do that.
Brendan, Hannah.
Stop. She wants
It's
to
burning up.
around.
You know it's hot if she says it's hot. That means everyone should be ready to pass out. What do they want with the Hannah? Okay, back on the record.
Your Honor, if I could inquire,
Yes,
I know there was some discussion earlier about Mr. Renner and that he had testified in the other earlier proceeding.
correct.
I guess I'm just looking for some clarification from Your Honor. Are we allowed to rely upon, once we get those transcripts, on that evidence and just use it? Or do we need to be, if, for example, Ms. Logan does not recall Mr. Renner for our part here? Are we allowed to rely on Mr. Renner's testimony in the prior hearing? Or are we expected to recall him again? And to do that, or Ms. Cox or anybody else? I'm not exactly sure everybody in Ms. Logan's planning on calling. But I guess I would ask that we just be allowed to
Well-
use the prior.
I don't think I can allow you to rely on it because if she called them, I mean, for testimony to be used against your client, then you have to have the right to cross-examine.
Okay, well, that's why I'm asking. So if we want somebody, then if we could get a list from the prosecutor of who she tends to call here. Oh, I didn't realize that was a final list, that these are all the people calling, because then we're gonna need time then to potentially send subpoenas to get some of these people here. We need to do that, so.
I believe under the rules of evidence, we could offer the prior testimony. Since the AG was a party and they had the opportunity to cross-examine a question of witness. I think that's under the rules. So I would suggest that all of the transcripts that anyone wants to designate be able to be used. That way we don't have to recall witnesses like tomorrow.
I agree with the court when the court says it can't be used against or I believe the court was inferring that it can't be used against my client because we didn't have to.
You didn't cross-examine those witnesses.
But I could stipulate if I so wanted.
You could
but
do
I'm-
that.
Right, I guess I wasn't clear, but that's what I was asking.
well, the transcripts only become admissible if there isn't a mutual stipulation, if the witness is unavailable.
Well, he's saying in lieu of a witness.
Well, we
Can
can
Yeah.
confer off the record.
If you all want to do a stipulation, that's one thing. I can't require that to happen. So you're asking me,
Can I ask? Are you
Let's-
gonna be calling me?
Can we discuss
Yeah,
this
we'll
off the
talk.
record?
All right.
That's fine.
oh boy, why do I have people in my waiting room? Oh, I was gonna say, oh, we should have restarted this Zoom. It's gonna boot us out. And I'm gonna,
Yeah, booted me.
let's do it right now. Is it the Polycom that boots us or the YouTube?
It's the problem. People don't shut that down.
Okay. Okay, you're still under oath. You can proceed, Councilman.
The last question was, what did Mr. Thompson know and when did he know it?
So on December 14th, 2020, he knew that as he was walking up to the state capitol, that as they approached the capitol to turn in an envelope, there was a gentleman there, Ian Norton, was representing the group and wanted to get the certificate of votes. He said that these were the Democratic the Republican electors there at Capitol to serve their votes. That's one of the things. So the Facebook information, there's a ton of information. It goes from comments that he was aware that there was other states participating in the same thing. I want to say it was posted on December 15th. There was he was there, so he was at the Michigan GOP headquarters on December 14th.
December 14th specifically, what time did he arrive?
I don't know.
Do you know if he participated in any pre-meeting or meeting criteria?
Yes, so Mr. Tony Zammit saw him there. Michelle Lundgren saw him there.
I'm not asking for who saw him there.
Okay,
I want to know what you know he participated in.
that's what I'm talking about. So I didn't get a chance to finish the meeting.
Don't care who else was there and knows he was there. I want to know what he participated.
He participated in the meeting of the electors.
The entire meeting?
I don't know that.
And do you know what time he got there?
No, I just answered that. No,
Did you inquire to try and find out what time he got there?
I did.
And what inquiries did you make?
I tried to ask Mr. Thompson.
And he doesn't have to give evidence against himself.
Understood. So that, according to my reports, it doesn't reflect what specific time he showed up there. So the people that did see him there did not, it does not say that in my report.
So let me come back. You know what time he got there?
I said no.
All right, just making sure.
Sir.
No is fine. Never mind. So it's possible that he got there 5 minutes before the meeting closed.
Objection, Your Honor. The witness said he doesn't know.
I'm asking-
Any question that asks at what time the witness got there, the defendant got there, is cause for speculation.
The question was a very direct question and it didn't require. He said he's investigated this thoroughly and he didn't know what time he got there. He got there, I give him that. But I wanted to nail down if it was possible that he could have got there 5 minutes before the meeting closed. That's a fair question.
The objection is overruled. You can answer.
So is it possible he could have got there 5 minutes before the meeting closed?
Yes.
You know if there was a sign-in sheet at that meeting?
There was one person that talked about a sign-in sheet. That was Michelle Lundgren.
Okay.
Aside from that, no, there was no sign-in sheet that was referenced that I can recall.
May I have permission to address the witness directly, handing documents back and forth instead of asking permission time and time again?
Yeah.
All right. Well, what do you know? I'm showing you what's already been introduced as People's Exhibit number 5. Can you review that real quick, please?
Sure.
Just kind of an overview. I'm not asking for
okay.
any detail off of it.
Okay.
specifically, can you look for on that, any place where it has an alternate elector?
Okay.
And that is the Democratic ballot sheet, correct?
Yes.
All right. Did you, when you look at that, yeah, can you tell when those replacement, the certificate of filling vacancies were completed?
Looking at this document itself,
I don't believe it does.
it says December, or the 14th day of December, AD 2020.
That's the date, but does it give a time?
No, sir.
Okay, and I'm gonna show you exhibit 11, and I've already pulled it to the same pages. And the page I'm showing you specifically, what is that?
The certificate of filling the vacancy of the 2020 electors from Michigan.
All right, that's the resignation of Terry Lynn Land, correct? Or that because
it's-
of the resignation of Terry
Yeah,
Lynn
it says
Land.
a vacancy has became known due to an absence of Terry Lynn Lang.
Right, and it was filled by Ken Thompson, correct?
Yes, sir.
On what date?
The 14th day of December 2020.
Does that indicate at what time?
No, sir.
So if there were all these communications or any communications prior to this date of any conspiracy to commit fraud or forgery, how would he be part of that if he wasn't appointed until the very last minute? The very last day, I'm not, that's a figure of speech. How would he know that there's conspiracy afoot if he weren't appointed until the very last day?
Troy Hudson had said that he knew that Ken Thompson would be coming to fill the vacancy.
Did he say? Troy Hudson said that? He said that he would be coming in at
Would
what?
be coming.
All right, and what day did this gentleman know that Ken Thompson would be coming? That day, the 14th?
I don't recall that.
Well, if he wasn't appointed until the 14th, how would the, was the gentleman you mentioned?
I'm sorry, Troy Hudson.
Troy Hudson know that he was going to be appointed and that he was coming if he wasn't appointed until the 14th?
It could have been that, it could have been that day, sir.
Are you speculating?
Yes.
All right, so do you have any evidence that Mr. Hudson knew that Ken Thompson was going to be appointed an alternate on the alternate slate because Terry Lynn Land was going to resign?
Just his statement.
All right, but you don't know what day or time or anything to that effect?
No, sir.
So you have no specific time, going back to what did Ken know and when did he know it? You said he went up to the Capitol House, correct? That
Yes.
might be. But that doesn't mean he knew anything about a conspiracy. Just because this other gentleman actually hand carried over any other documents.
Yeah, and I'm gonna object and ask that council ask the question
I'm laying
instead
the
of
foundation
testifying.
for it.
You're giving testimony though, so,
Well, it's a information he's testified to. It is nothing new.
okay.
You'd indicated that somebody else walked the documents over. The alternate slate.
Oh, there was a group of people.
Right, a group of people,
Yes.
but not everybody didn't have their hands on it.
No,
All right, so it was one individual, was it Mr. Thompson?
I didn't see Mr. Thompson with the document.
Okay,
Or
so
with
that-
the envelope.
All right, so that was after the fact that they had been signed. And that slate, I think, it even indicates that the document was signed on the 14th. Mr. Thompson wasn't as a elector until the 14th. My question still remains, how did he know that he was going to be participating or that there was even a conspiracy for him to participate in?
Based on the meeting that he participated in.
That meeting in the basement.
Yes,
Prior to that, how would he have known?
I don't know that.
Did you have any evidence directly that would lead you to believe or prove that he did know or was in the loop of communications that this was going to be a contested election or anything to that effect?
So we had,
Yes or no?
there may be, I don't know the answer. I can't recall. I'd have to refer to, there was some search warrants that were done on call detail records. I would have to reference those records to know if his phone number may have been in there and been called on that.
Let me make it simple.
Okay,
Do you know when Terry Lynn Land resigned?
no,
Do you know if they had, who all had knowledge of when she was gonna resign?
it was, I don't recall specifically when, if she made it known that she wasn't gonna participate, and I believe she had a conversation with Laura Cox about that.
Do you ever know when she had that?
I would have to refer to.
All right, did she, did, to your best of your knowledge, did she resign on the 14th or before the 14th of December?
I believe it was before the 14th.
Do you know by how many days?
I don't.
Do you know if when she resigned, they tried, or that her position, if her position was tried to be fulfilled or filled with other people other than Mr. Thompson?
Did you say that again, sir?
If, when she resigned, her position had to be filled.
Yes.
Do you
Your
know?
Honor, I'm sorry, I'm gonna have to object because there's a continued mischaracterization of the evidence. There's no evidence on this record that Terry Lynn Land resigned. In fact, the document says absence of Terry Lynn Land. It does not say resignation.
I asked if she resigned, he said yes, so I don't know if,
No, I think he was responding to your question about her resigning and whether she resigned on December 14th or before.
good enough, I was trying to,
Okay,
so
thank
she
you.
didn't appear that day then, correct?
Yes, sir.
And that would have been the only day she could not appear, correct?
Yes, sir.
So they couldn't have had any, they couldn't have contacted him until the meeting started and she didn't appear, correct?
Well, no, some,
Yes or no?
no,
Why not?
she may have communicated that she wasn't gonna appear before then, and somebody may have received notice.
May have, are you speculating to that answer?
No, I'm going back to my first response, which was I would have to reference the conversation that took place with Laura Cox.
Very good. When did she fail to appear?
She failed to appear on the 14th when you would be due to appear.
All right, and she didn't appear because that says she didn't and they need to fill her vacancy, correct?
Yes, sir.
So it couldn't have been any sooner than that her vacancy could be fulfilled, correct?
Yes.
So I'm gonna kind of go back around to it. How did Mr. Thompson know prior to that date that he was being called in to participate in a conspiracy?
Again, I would have to refer to maybe the call detail records that may show that he was called. I did receive statements from both Troy Hudson and Tony Zamet, said that there were some people in the lobby trying to call what they believed. Again,
All right.
this is hearsay, so.
That might help us flesh it out. Nobody's objecting. Go ahead.
Okay. So that they were calling around to alternate, or what would be alternate electors to fill that vacancy.
So somebody from the core group or the original group was making calls to other people. You don't know necessarily who, and you weren't given information to that effect.
Ms. Sean Maddox.
They were making the calls. You don't know who they were making the call to.
Yes.
All right. So they had to fill 2 vacancies. Was it because of absence or resignation?
Because of absence.
Okay, so 2 people failed to show up. They had to fill 2 spots. Again, what information do you have that Mr. Thompson knew he was being called in to participate in a conspiracy?
Again, I would have to look at the call detail records to show if I had that information. Any bit of that information may appear on the call detail record.
From a logical perspective, unless you knew, strike that. I want to phrase this so it's going to work. Gonna rob a bank. Hypothetically. 3 people need to go into the bank. You need to have a car. a driver, kind of like that Progressive commercial.
Yes,
So the people go in, they're getting ready to rob the bank. They realize right at the last minute they don't have a wheelman. So they call somebody that professes to be a wheelman. They get out, they find this progressive dude who has no clue what the heck's going on, but he's now participating in a bank robbery. True?
yes.
Do you think that that person had prior knowledge?
And we're dealing with hypotheticals.
I know, I'm
Mr. Gilbert.
gonna ask you to draw comparisons to the two in a minute.
Okay. Do I think that the person had knowledge? Well, yeah, they could have had knowledge. They
Could've.
the person could have said, hey, listen, we're inside robbing the bank. We need somebody to drive away the car. Maybe they didn't.
And
I
that's
don't-
why I'm asking you, do you have anything where you have any information where Mr. Thompson was called and said, we are committing or we are participating in a conspiracy to defraud? We have the wheelman failed to show up. We need you to come in and help us commit this fraud. Do you have any evidence that supports that theory?
I've tried to answer your question,
I-
Mr.
and you're
Gilbert,
going-
by
yeah.
going back to the
Okay.
call detail records again.
You-
And I'm not trying to be difficult.
You, in the call detail records, what does that show?
It says outgoing and incoming.
Doesn't show any of the contents of the call. It just says they called Pete on Tuesday at 10 o'clock.
Yes, sir.
So if Mr. Thompson got a call from any one of these people, it could have been an innocuous call.
Yes, it could have been, but again, if it was around the time that maybe Michonne Maddock was calling and she had called him, or some of the other call detail records that we obtained, then it may fit. But again, the call detail records don't contain a script. So
Okay.
to answer your question, it doesn't have
Right.
a message.
But you just said that it may fit, that it doesn't necessarily mean that it would fit, correct?
Yes,
All right.
I did say that.
And then when we look at all this and the political season's hot afoot, which it was specifically on those dates, I mean, there was a lot of controversy in the air. The press is doing a lot of stuff. Wouldn't that seem to be an appropriate time for people who are politically participating to be calling each other and saying, hey, did you see the news? So that there could have been a lot of communications between these people, totally innocuous and not of nature of any conspiracy, correct?
Yes, but there may be,
Correct?
yes.
Thank you. So are you suggesting that by Mr. Thompson walking over to the Capitol with the rest of the electors, that that was in furtherance of the conspiracy?
Yes.
And how so?
So they had just met at the Michigan GOP headquarters for the meeting. And so walking over to the Capitol, yes, trying to serve that document. And Mr. Northen lays out what's inside the envelope and why they're there and what they're doing and what their intentions are.
Okay. And their intentions were to serve the document, correct?
Yeah, to serve their votes. The
Okay.
electoral votes.
And were they allowed to do that?
No,
As a matter of fact, when we look at their votes, we heard yesterday a lot of testimony about they were sent to this person, that person, et cetera. Were their votes ever counted in the official tabulation for president and vice president that year?
when you say they're,
The Republicans, when they tried to serve their alternate ballots, which I would prefer to serve their alternate ballots, they weren't tabulated in any way.
not to my knowledge.
So did they complete the fraud?
Yes.
How?
By, again, trying to serve them and then having them mailed off to, and they made attempts in the totality of my investigation to try and serve them to the vice president or president. of
Well,
the
isn't
Senate.
there a difference of a murder and attempted murder? If I shoot at you and you're like the Catwoman and you avoid it, Isn't that attempted murder? And then if I shoot you and kill you, that's murder, correct?
Yes,
I'm assuming all the other facts are there.
Yeah.
So if I don't complete the whatever's necessary for murder, I didn't complete the crime for murder, maybe something else, but not for murder. Correct?
yes,
So what did they do? How did they complete the fraud?
by, well, let me look at the document here. By signing the document.
That's
says-
the forgery. I want to know the fraud.
Your Honor, I asked that the witness be allowed to answer, complete his answer.
Allow him to complete.
The fraud is, so they signed the document. It says here in the document, we convened and organized at the state capitol, the city of Lansing, Michigan at 2 p.m. on the 14th day of December. That wasn't true. They tried to serve the document when
I'm sorry, you said what wasn't true?
that they didn't meet at the state capitol,
Okay,
at 2 p.m. Again, trying to serve the document to the governor, and then mailing the document off. Again, this is mailing it off to the.
okay. And you keep referring to they tried to serve the document. In all those pictures that you see, is there any picture that actually shows the documents, or does it just show an envelope?
It shows the envelope, but he says that he has the documents in there. He has.
That's hearsay. Is
Yeah.
there any picture in there that shows the documents? It just shows the envelope, correct?
In that particular video, yes.
All right. So we don't really know what's in the document.
What's in the
I'm
envelope?
sorry, what's in the envelope,
I-
do we?
No,
It could have been empty.
it could have been.
So in your investigation, did you ask anybody if the envelope contained anything?
Well,
Yes or no?
the envelope that Mr. Norton's
Yes.
holding, I don't recall.
You don't remember if you asked anybody if it was in there?
I
What
believe
was in
they,
there?
I don't recall what they said. I believe it was something the fact they didn't know.
So we have no idea what was in that envelope.
No. Other than what he's professing to be delivering.
That's not one of the defendants. That's an attorney who was leading this group, correct?
Right,
I
but
strike the part about
but
leading
he's-
the group.
Objection,
He
Your
was-
Honor, I couldn't hear the answer.
You
There's
allow-
some crosstalk.
Thank you. You let him respond.
I'm sorry,
what was your question again?
I couldn't even tell you at this point. It was, had to do with the contents of the envelope. We don't know what was in the envelope because there was only one person that carried it over to the Capitol building, as far as we know, correct?
Yes, sir.
All right. And then I think I followed up with, were you able to ascertain what was in the envelope? Other than what the attorney was professing was in.
Yes, through Mr., I believe through the interview with Mr. Renner.
And in his interview, he positively identified what was in the envelope.
I would have to go back.
Do you recall if he knew for certain what was envelope, or was it more of a belief?
No, I said, I don't recall what he said. I would have to go back and reference it.
I'm gonna get to continue with you tomorrow, but I would ask you to research that question, preserve the question,
Sure.
Your Honor.
Yeah, repeat the question. That you want to
That
preserve?
one of the witnesses has indicated that they were believed what was in the envelope. And I asked the witness asked this witness if the interviewee had made the comment for certain, yes, I know, or was it I think? And he had indicated this witness indicated he'd have to review his record. Preservation of time, I preserve the question until tomorrow, the answer until tomorrow.
And just to add on to that, because I know you stated sometimes you can't remember names. The witness was Mr. Renner.
Yes.
It may have been
Right.
Mrs. Long.
I'm curious who the interviewee was. Was that person identified?
Mr. Renner.
Brenner. Okay.
Okay.
And if your honor didn't have Simmons on the tag up there, I wouldn't remember it. I'm sorry.
It's no problem.
So that's one answer you're gonna try and ascertain from there. So I'm still going back to how did they perfect the charge of fraud? Because from what the testimony we had yesterday, what you've been able to testify to, those GOP ballots were never counted, correct?
Correct.
All right, so how did they perfect the fraud?
Say it again. So they signed off on the document. The document says that they were in a specific place when they weren't there, being the state capitol building at 2 o'clock. And the documents were attempted to be delivered to the Capitol.
Would you agree with me?
They tried to deliver them. They were rejected and they were mailed off. Again, these weren't the legitimate documents. So they did not have a certificate of ascertainment. They did not have anything with the seal on the state of Michigan on them. They did not have anything with the Secretary of State's signature or the governor's signature on them.
I agree with you 100% on all those things.
Okay.
I'm still asking, and I think that goes towards what you might be considering the forgery. I'm still looking how they did the fraud.
That's
That's what you think?
That's
Okay.
what that's my response.
All right. So when we look at a forgery, there's some specific elements that go to forgery. And a lot of times I think of money when I hear forgery.
Okay.
And I'm not trying to be smart aleck here. You've seen real money, correct?
Yes.
And you've seen monopoly money, correct?
Yes.
Is there any chance that you would mistake the two to be the same? That one was legal tender, the monopoly money was legal tender?
No, but I have
Yes or
seen,
no?
I have seen money that is presented that is very similar to the authentic currency.
I've produced it inadvertently doing that, but nonetheless.
But if we're referring to the monopoly money as the game of Monopoly, is
Yes,
that what you're referring
Yes,
to? Okay, I didn't know. So, no.
okay. So when you compare 5 and 11, there's distinct differences between those two documents or packages of exhibits, correct?
Yes,
One has a certificate of ascertainment, is that correct?
yes, sir.
One is has a document signed by the governor, correct?
Yes, sir.
And the other one doesn't.
Yes,
So by clearly looking at the face between the two, you know there's a difference between the two, correct?
yes.
Were you fooled that that was a legitimate document? Yes or no?
To me, it's presented as a
Yes or no?
legitimate.
Were you fooled into believing that the alternate slate was a legitimate document? Yes or no?
I wasn't fooled.
Okay.
I-
And the testimony we heard yesterday from the House Counsel for the Secretary for the House, he indicated that he looked at it and said, ain't no way. Something to that effect, correct?
Something to that effect.
And Lara, when they got that document, they looked at it and they said, this ain't it. We're just gonna make it kind of a cursory thing. We're gonna record it, but we're not recording it as the, excuse me, true ballot, correct?
That's what they said.
Well, that's what they testified to, correct?
Yes,
So in all of this, all the experts have agreed that those aren't even close to being accurate. And they were noticed flat out first thing right off the bat, correct?
primarily
Yes or no?
because they
Yes or
didn't have
no?
their certificate of ascertainment. So,
When I look between the two and I look at the ballot itself,
they look different.
right.
The ballot is exhibit
But-
6.
Well,
I
I'm
was
sorry,
gonna say,
exhibit 6, I'm sorry.
okay, that's where
Yeah, there we go.
part of my confusion is
Exhibit
coming
that
in.
way, I don't,
Okay,
not intentional, but I've been confused for several years. This is, it says, it has the seal of the state of Michigan on it, ballot number 6. And this is a certificate for president, the votes for president, vice president. And this is for the Democrat Party, correct?
Yes,
All right. Is exhibit 6 included in the Republicans' packet of documents?
no,
Do you think a layperson could look at these documents and say, hey, there's a difference between the two?
yes, but.
Do you believe,
looking at-
thank you,
Looking at.
thank you. Do you believe the people that are in Washington that deal with this stuff on a regular basis could make an instant distinction between the two?
Your Honor, one,
No.
I'm gonna object because first of all, it calls for speculation, but whether or not somebody buys the forgery is not an element of the crime.
Want to respond to the objection?
Goes to if it goes to the distinction I made earlier between real money and monopoly money. If there is such a difference that there's a vanishing point between what is real and clearly not real, then there cannot be a forgery, because then it has to go back to the intent. Did I create a document with the intent to show that this is valid money or a valid document to defraud somebody or to get this to gain an advantage? And when we look at the two, testimony yesterday said there's a huge distinction. He's saying there's a huge distinction. Everybody looked at it, the face of it, and said, that's a huge distinction. So what the basis of the forgery is, did they forge this document? And that's what I'm trying to get down to, and I can do a little bit more
Was that your
clearly.
question?
That's the crux of it. Which I
That
can
was-
rephrase. I
That
can
wasn't- that
rephrase.
wasn't the way you had
That's
it.
the crux of it. I can rephrase.
I'm okay with
Thank
that
you.
question.
Thank you.
Did they forge a document that looked like exhibit 6?
They forged a document that it's different, but it's still intended to accomplish the same thing.
That's your inference based on a totality of the information,
Of the
correct?
information, yes, sir.
Right, so but that's a question of fact, correct? But you think that that was their intent, correct?
Yes, sir.
If I look at People's 5 is what we would consider the Democrat ballots, correct? I think, is that it? Am I backwards?
Yeah, this is the
Okay.
certificate of ascertainment.
I'm sorry, certificate of ascertainment. And then, but between
This
everything,
is the certificate of vote.
right. Would it make sense to you if I was a criminal trying to pull off anything, that I would try to duplicate it as close to the original as possible?
Objection.
Goes the intent of his understanding of the intent of the crime.
She
If I,
didn't say her objection yet.
Oh,
What
I-
is the objection?
Well, it calls for speculation, and you just said a criminal. So, I mean, I can't even bring that back to the relevance of why we're here.
I'll rephrase.
Thank you.
Wouldn't you think that this group, if they were gonna try and pull off a fraud, that they would duplicate their vote or all their documentation to make it look as close to exactly as what should be properly submitted?
I can't say if they would or they wouldn't. I've seen a lot of different things and, so I can't say,
Well, you
you know,
justified,
that they would do it in a blue and gold in this format versus this format.
we testified earlier that all these
Your
people,
Honor, I asked the witness to be allowed to complete his
it
answer.
was a yes or no question. He answered it.
He said
It didn't need explanation. It
he
didn't-
did answer, it was a yes or no question. He's providing additional answers.
You had testified earlier that you felt that all these people were, or at least the majority of them, were suave in their knowledge of the political format and arena, and that they knew what was going on. And that they should know if they're gonna try and pull off something like this, that they know how to do it.
I'm gonna object. I think that mischaracterizes the testimony.
Actually, that's paraphrasing exactly what he said. He said,
Suave.
I said paraphrasing.
Well,
They had the know-withal, intelligence, and knowledge of how to do it. Is basically what you said, correct?
I don't agree with basically what I said. I just,
All right, then let me ask you, do you believe that they had any of those abilities or knowledge?
I believe based on the totality of my investigation that they had.
Not my question.
I,
Would I
Can you-
court,
that's good again, maybe, then.
do you believe they had the knowledge to duplicate those documents?
This document?
All of the appropriate
this
ones for the, both, all of them that would be required for the ballot.
They may have, I don't know.
Will you, so you're saying you don't know if they could do that or not?
No, the knowledge to duplicate this specifically,
That's, that they should. Ability and knowledge, two different things.
okay.
Ability is one, knowledge.
Oh, I'm sorry.
So if,
Clarify, please.
yeah, I'm sorry, knowledge, that if they were gonna try and do this, they'd have the knowledge that those should be the documents they should submit.
They could have, I don't know.
All right, do you think they had the ability to do that?
There's 16 people, they could have, I don't know.
Did they do either one?
No,
Any of them?
these.
Right, they didn't.
No, sir.
And then you're saying that there's a fraudulent document. What about that document is fraudulent, or counterfeit, or?
Well, this is the legitimate document,
Well,
which was,
I'm asking, I don't care about the legitimate, I want to know about the other one.
I'm trying to explain. So part of my explanation.
Okay.
Your Honor, can we use some exhibit numbers, please?
yeah, what exhibit are you asking is, what is, you asking about which about that document was fraud? But which
Well,
one are you
there's-
talking about?
There's 6, 11,
Um,
and 5, I think, are all the documents that would normally be sent in that were sent in.
Right, but
by-
your last question was, what about the document is fraudulent?
I'm sorry, what about the Republican submission was fraudulent?
And we want an exhibit number for that one.
That's exhibit 11.
hold on.
Thank you.
Exhibit 11. Okay,
The entire thing,
How was it fraudulent?
because it's not the 2020 certificate of votes of the electors from Michigan,
Is it the certificate of votes from the Republicans?
but it doesn't, it says the
Yes or
certificate of
no, sir?
votes from the 2020 electors of Michigan.
Is
It is the certificate of votes from the Republicans who are not duly elected and qualified electors. Does that answer?
So you're saying that because you believe they were not duly qualified electors, that makes that document a forgery?
That's part of it.
What else makes that document a forgery?
Well, as we discussed just a few minutes ago, we have on December 14th, 2020, we convened in the state capitol, city of Lansing at 2 p.m. We had 16 votes for Donald Trump and 16 votes for Michael Pence. We have signatures from the 16 individuals who
Okay,
are
the
reported
signatures,
to the electors.
got it. I'm gonna interrupt you there.
Okay,
Are any of those signatures forgeries?
no, sir.
Their declaration is inaccurate. Correct?
Yes,
How can that declaration be a forgery? I'm king of the world.
well,
I'm not king of the world, and I put it
so
right in
again,
how
with
it's
the
a forgery.
with the totality of the investigation and it being submitted to the Capitol and then to the National Archives and Senate.
It was not submitted to the Capitol. Agreed?
It was,
It was not submitted to the Capitol.
it was.
It was,
that
It was
yes or no?
rejected, it was rejected.
yes or
from-
no? Wasn't submitted to the
It
Capitol.
was rejected from the.
It
Capitol.
was not
No.
submitted to the Capitol.
So could you
Yes or-
define what submitted?
Well, you just said submitted. You tell me.
So it was submitted, meaning it was somebody tried to turn it into the Capitol. That's submitted, like walking
the
up,
court would, I
passing
think,
passing this over the counter is submitting something.
okay, and who
So
did they give it to?
the state police.
I believe the state police in the video never took it. I think they held their hands up and said, nope, not gonna take it. Correct?
Yeah,
Yeah.
I believe that's what the witness said, that it was rejected.
I'm just
That's what
clarifying
I
that.
said.
But he said it was submitted, and he said by passing it over and there's somebody receiving it.
But you did say someone receiving it.
Yes, I did, Your Honor. So that was my mistake. And yes, it was passed over. It was rejected. So
When
in
you say
my,
passed, I'm sorry, when you say passed over, he reached out in effort for the person to take it,
to take it. So that's,
but he never took it.
that's my interpretation of submitting. Meaning it was, he reached out for the person to take it. They just rejected it.
So in other words, if I go to the store and give them a fake $100 bill and they rejected it, I was successful in passing that bill,
You attempted to pass the bill.
but I wasn't successful. That would be a different crime altogether. That would be an attempt, wouldn't it?
I would, yes,
All right.
yes,
So they never successfully submitted that to the Capitol, correct?
yes,
And they needed to do that to complete their forgery and the completeness of this, correct?
no,
Didn't it have to go to the floor to be certified so that the governor could look at it, sign all her documents, and the Secretary of State sign it? Sign their paperwork to complete it?
yes, but then in turn, they sent it
Just
to
yes.
the, they sent it to the
I'll
mail.
get to that.
Okay,
So they never completed the formality of delivering it to the Senate or to the Capitol in Michigan, Lansing, Michigan, correct?
they delivered it, it was rejected.
What's your definition of delivery, sir?
That's what I just tried to describe is I hand the document to you. That's attempting to deliver.
It's not what you call
Deliver,
but okay.
it's delivering, I'm delivering something to you.
Right.
If you choose not to accept it, then I still delivered it to you.
Have you ever done a
So
service
it's-
process?
What was your question? He says it.
I've asked him if he's ever done a service process.
No, I have not. sir.
Have you ever delivered a package?
Professionally,
Ever?
yes, I've delivered a package.
All right. So you consider that if, let's say FedEx drops a package at your door, they've delivered it and you're bound and obligated to pay for that package?
It all depends upon the terms and conditions.
Well, let's say that it was COD, they delivered it, now you gotta pay for it, correct?
Yes,
All right, what if somebody stole the package?
okay.
Are you still bound and obligated?
Objection, Your Honor, relevance.
I'm trying to get the nail down to his term for delivery.
Yeah, I think we're trying to understand. I agree where he's trying to go. He's trying to get a definition of what he believes or understands delivery to be, just like the definition of what he believes submitting something or an attempt to. First, I think that's where we're trying to go.
I'm just trying to nail it down.
I think the witness defined delivery, and I think it was almost synonymous with his definition of submitted. But I believe that was a question that was previously answered by the witness as to how this witness defines delivery.
And that goes to the factual basis of he's saying that they completed part of their criminal conduct by delivering, proffering the package, whatever. And it goes back to my argument, if I shoot at you and don't kill you, I didn't commit a murder. I want to know how these two line up. Just because I attempt to deliver something doesn't mean it was delivered, just because I attempted.
So you want to know why it wasn't an attempt fraud versus fraud?
Correct.
Why it was, is that what you're asking?
Why he doesn't consider it an attempt.
Well, I think that's a legal conclusion.
Oh, it
and-
doesn't matter.
But my objection was to the scenario about the box. That's all I was
I think-
objecting
I'm
to.
trying to nail it
At
down
this
to
point, I
what,
think we moved on beyond the boxes.
I know,
Yeah.
I just
Yeah, I
want to get
agree.
this back on track. I'm sorry.
so their attempt, the way I see it, or understand what you're saying, is they delivered it, but it was never received.
Yes.
And if the House didn't receive it, if Lansing didn't receive it to count it, how did they complete the fraud with that aspect?
Through the submission through the National Archives.
No. The aspect of delivery to the Lansing only, in just relation to Lansing.
Just that was through their intent
You're saying that their intent was to
to
deliver,
deliver it. Yes.
but if it was never counted or accepted, how does that go to completing that aspect of it with Lansing? How can that be completed if it was never received?
It was, I can't answer that. I'm trying to understand. You know,
Fair enough.
it was delivered.
Fair enough. I think I understand your perspective. Your Honor, my head's about ready to pop off. Can we call it a day?
It's up to you. It's your question. If
Well,
you're ready
I'm
to,
not done
if
with
it's
the
a good way, I know you're not, but I didn't want to make you break where you didn't feel comfortable
No,
with breaking.
this would be a good hash mark for me.
Sounds good. Okay, so we'll continue tomorrow. There was a question that you preserved and we'll begin with that question.
Yeah. Can somebody write that down? 'Cause
Yeah,
I don't even
I don't-
remember
I remember
what
the
the question is.
You said did an interview with Jim Renner
Oh, that's the
that
one. We weren't sure, generally speaking, we weren't sure if he had said, oh, absolutely, he knew what it was in it, or what, if he
Yes.
knew what he thought was.
the
in it.
contents of the
Oh, the
envelope
contents
that
of the
was
envelope,
yeah.
presented.
I gotcha.
Sure.
That's all for today. We'll be back tomorrow, 8:30.
Um,
Any additional matters for the record?
Never give them back to the lawyer that didn't originally have them, because I'll lead them.
You're all set for today, Ms. Rodriguez.
Your call.
Thank you.
So, Madonna.